Good morning, everyone. Thank you so much for being here. It's really a pleasure. We are very excited to have you with us today and tomorrow for the first global conference on climate litigation, co-hosted by the Sabin Center for Climate Change Law and the United Nations Environment Program. I am Maria Suter, the Global Climate Litigation Fellow at the Sabin Center. Welcome to our esteemed panelists and a very diverse audience from all corners of the world. Thank you for joining us in different time zones and for the remarkable interest in this conference so far. The conference is a result of the long-standing partnership of the Sabin Center with UNEP. This partnership has resulted in publication of 2 reports on the status of global climate litigation, one published in 2017 and the second in 2020. We are currently working on the 3rd report on the status of global climate litigation, which we expect to publish by the end of the year. The reports are based on the Sabin Center's groundbreaking database on global climate litigation, which has been maintained since 2011. As you all know, greenhouse gas emissions continue to grow and climate change is already causing widespread disruption worldwide at 1.1 degrees Celsius of global warming. The latest IPCC report finds that every 10th of a degree of additional warming will escalate threats to people, species, and ecosystems. The effects of climate change are disproportionately felt across the globe and by vulnerable populations, causing inequality and development challenges, especially in the global south. While countries worldwide have increased their mitigation pledges leading up to COP26, UNEP has calculated that the world is on track for the 2.5 degrees warming by the end of the century, which remains extremely dangerous and far from the Paris Agreement's 1.5 goal. Climate change litigation, therefore, continues to grow in light of the scientific consensus on the sources and impacts of climate change and the still inadequate responses to mitigating greenhouse gas emissions and adapting to the consequences of global warming. As part of our continued efforts to update and maintain the Sabin Center's global climate litigation database, the Sabin Center launched with UNEP the peer review network of global climate litigation in December 2021. The network includes practitioners and scholars worldwide who volunteer as national rapporteurs within their country of origin, who help us maintain the database comprehensive and regularly updated. As of today, the network includes 65 national rapporteurs covering 54 countries or international adjudicatory bodies. We are still looking for rapporteurs for the jurisdictions not yet covered, so please consider applying. As a result of the network, the number of cases in the Sabin Center's database has increased substantially. Over the past 3 months, we have added over 70 new cases to the database. These include cases filed before 2020 and therefore not covered in the 2017 and 2020 status reports, as well as new cases filed in 2021 and 2022. The network has particularly shone a light on several jurisdictions in the global south where cases are not easily accessible to non-native speakers. This increase in numbers reflects an ongoing work on the expansion and true globalization of the database. This conference reflects some of this work. We have amongst us several of our national rapporteurs, as well as some renowned invited keynote speakers to talk about the current status of global climate litigation, as well as some predictions for the future. So I'm very excited to now welcome you and present our next speaker. He's going to give some introductory remarks and a welcome from the United Nations Environment Program, Professor Patricia Kameri Mbote, who is the director of the Law Division at UNEP. Thank you.
Thank you very much, Maria. Good morning, good afternoon, good evening to our distinguished speakers, panelists, and participants joining us today. It is indeed my pleasure to address you at this annual Climate Change Conference on Climate Litigation. The UNEP Law Division is proud to collaborate with the Sabin Center for Climate Change Law to organize this event and to welcome you all to share and discuss important developments in climate litigation taking place across the globe. In January 2021, UNEP collaborated with the Sabin Center to develop and publish the Global Climate Litigation Report 2020 Status Review that Maria was talking about. This report provided a survey of global climate change litigation and an assessment of global climate change litigation trends. The findings were compelling. The report, for instance, found that from 2017 to 2020, a rapid increase in climate litigation had occurred around the world. In about 3 years, the number of climate change cases identified nearly doubled, increasing from 884 cases filed in 24 countries in 2017 to 1,550 cases in 38 countries. Importantly, the report revealed that climate litigation was driving significant action on climate change. Climate change litigation has been responsible for pushing governments and corporate actors to intensify efforts to mitigate and adapt to climate change at the national level. It has led to the establishment of new climate goals, more extensive climate regulations, and stronger environmental impact assessment regulations in countries. For private parties, climate change litigation can result in the delay, alteration, or stoppage of proposed activities found by courts to contribute to climate change. Climate change litigation has also been instrumental in recognizing and enforcing human rights in countries around the world. The report found that increasing numbers of cases are relying on fundamental and human rights enshrined in international law and national constitutions to compel climate action, challenge domestic enforcement and non-enforcement of climate-related laws and policies, and address failures to adapt to the impacts of climate change, among others. The 2020 report noted an increase in the number of cases where courts have recognized that insufficient action to mitigate climate change may violate plaintiffs' international and constitutional human rights. In many of the climate litigation cases identified, the plaintiffs represented women's groups, young people, senior citizens, and indigenous peoples, among others. Climate rights cases have resulted in safeguarding rights for such marginalized and vulnerable social groups, more likely to be disproportionately affected by the impacts of climate change. The October 2021 United Nations Human Rights Council resolution declaring for the first time a human right to a clean, healthy, and sustainable environment provides fertile ground for these to be further explored. The findings are insightful because they shed light on experiences in countries on how environmental rule of law has functioned to promote sustainable development. Access to justice is one of the core elements of the environmental rule of law. UNEP's first global report on environmental rule of law, published in 2019, emphasizes that a well-functioning legal system provides accountability and relief for both actual and pending environmental harms. Environmental enforcement and dispute resolution seek to provide accountability and consistency in environmental law and to discourage future harmful behavior. The 2020 Climate Litigation Report revealed that in many parts of the world, individuals are demanding and in several cases obtaining access to justice in important environmental matters. A review of the body of climate change litigation also makes it clear that the judiciary plays an invaluable role in interpreting environmental law and upholding human rights. Effective adjudicators who are also knowledgeable about environmental law can deliver swift and efficient justice in environmental matters. They are essential to providing a culture of compliance and are a key ingredient to enabling access to justice. The importance of climate litigation in promoting the rule of law is evident. Without environmental rule of law, development cannot be sustainable. So too, is it important to ensure that developments in climate litigation are captured and documented, and the experiences shared from country to country. Growing concerns about the rights of nature are likely to open new pathways in climate litigation. That is why UNEP is working on the development of an updated climate litigation report due to be published by the end of this year. This report will build on the findings of the previous climate litigation reviews and will outline the status of climate change, and will outline the status of climate change litigation worldwide, as well as highlight key trends and future directions. Recently, the Sabin Center, with support from UNEP, developed a peer review network that Maria spoke to us about, and you will be hearing more about this throughout discussions that will be heard at this meeting. This network, made up of climate change scholars and practitioners from around the world, aims to provide review and updates to climate change litigation globally and ensure that the geographic scope of the findings is as comprehensive and inclusive as possible. I genuinely look forward to the discussions over the next 2 days and take this opportunity to thank the panelists, members of the peer review network, distinguished judges from jurisdictions around the world, representatives from international and national organizations, scholars, lawyers, and plaintiffs in climate litigation cases, among others. Tackling climate change requires action at all levels and by all actors. Your contributions to this dialogue will no doubt add to the flavor and richness of these discussions and will deepen our knowledge and understanding of this emergent area. I thank you for your attention and wish you excellent deliberations. Thank you.
Thank you very much, Professor Maria Suter, for these wonderful remarks. Now I'd like to invite Professor Michael Gerard, our professor and director at the Sabin Center, to give some welcome remarks as well.
Thank you very much, Maria Antonia, and thank you for playing such a key role in organizing this effort. Let me start by sharing my screen. Here we go. So the climate litigation chart that we've been talking about actually had its origins in 2007 as a way to update the first edition of my book, Global Climate Change in U.S. Law. So it started just having U.S. cases. Then in 2011, we expanded it to cases around the world. And many of you on this program are contributing to its further expansion. This is a graphic prepared by our friends at the Grantham Research Institute, based largely on our database. And as you can see, the number of climate litigation cases has been rising, especially since 2007. The cases that are from the US are in pink and from the rest of the world in the darker color. Our latest count is 1,994 cases globally, of which 72% are from the United States. Australia is a distant second. The UK is a distant third, but we see many countries have quite a few cases, and there are some that have two and some that just have one. Since such a large percentage of the cases are in the US, I'm going to talk about those cases now. The largest number of US cases by far are under the National Environmental Policy Act, NEPA, which is our environmental impact assessment statute, followed by the state equivalents. Several states have similar laws on their own, led by California. And so these are cases that mostly allege that the environmental review of a particular project or action did not adequately consider climate change. We also have quite a few cases under the Clean Air Act, the Endangered Species Act, and other wildlife protection laws and various other enactments. A relatively small number of the cases are brought under common law theories and under public trust claims, but these cases have received much more attention than many of the others. The most important US climate decision was the 2007 decision of the US Supreme Court in Massachusetts versus EPA, which established that greenhouse gases are pollutants within the meaning of the Clean Air Act, and that the Environmental Protection Agency has authority to regulate them. This decision led to a great deal of regulatory activity during the Obama administration. The Trump administration tried to dial it back, and the Biden administration is resuming it. In February, the US Supreme Court heard argument in a case called West Virginia versus EPA. Many people are concerned that the resulting decision from the court may lead to a reduction in EPA's authority under the Clean Air Act and possibly beyond. This decision is expected in May or June, so we'll see what happens. But meanwhile, the litigation has been very important in the US in spurring or challenging regulatory action. Many of the actions that the Trump administration took to try to dial back on environmental regulations were struck down in court, mostly because of procedural issues, because of failure to have the necessary notice and comment period or the right kind of environmental impact assessment or so forth. There have been efforts for years to try to use common law claims, mostly against companies in the energy industry. A very important decision was in a case brought by the state of Connecticut and other states against several power companies seeking an order that the power companies reduce their emissions from coal-fired power plants. The Supreme Court said this case needed to be dismissed. It was brought under the federal common law of nuisance. And the court said that because the Clean Air Act empowers EPA to regulate greenhouse gases, there was no need for no place for a federal common law of nuisance, because that law is aimed at filling in gaps in the law, and there was no gap. This case was about seeking an injunction, but there was another case pending at the same time brought by a village in Alaska that was endangered by sea level rise, that was melting around the protective ice and so forth. This was seeking money damages. It was seeking money to relocate the village to a safe place. But the court found that the same doctrine from the Supreme Court case for injunctions also applied to money damages. The Supreme Court had left open the issue of whether state common law could be used for these kinds of cases. The Supreme Court had thrown out one case using federal law, but state common law, that question was left open. And beginning in 2017, we had cases brought by various, mostly cities and counties and then states around the country, all of them against fossil fuel companies, all of them seeking money damages for the impacts of climate change and the cost of preparing like seawalls, and all of them seeking to use state common law theories. The plaintiffs, the states and cities and counties all want to be in state court. The defendants all want to be in federal court. And we now have about 20 of these cases, and they've all been held up on the question of, do they belong in state court or do they belong in federal court? This issue has not been finally resolved, but until it is, it's likely that these cases will be further held up. Another important series of cases was brought under the public trust doctrine, and Professor Mary Wood of the University of Oregon Law School advanced the theory that the public trust doctrine applies to the atmosphere, and that governments have an obligation to prevent the atmosphere from having so much high levels of greenhouse gases that it causes dangerous climate change. An NGO formed in Oregon called Our Children's Trust, which brought many lawsuits or organized many lawsuits under these theories. And almost all of them were dismissed, either because the courts found that the plaintiffs did not have standing, or the atmospheric trust doctrine wasn't really valid, or that this would be the courts intruding on the on the job of the other branches of government. However, the Juliana case became very prominent, brought in 2015. And one other case, a case in Montana, has been scheduled for trial beginning in February of 2023. So the Juliana case, brought by 21 young people against the federal government, sought very ambitious relief. It sought an order compelling the defendants, the federal government, to prepare and implement an enforceable national remedial plan to phase out fossil fuel emissions and draw down excess atmospheric carbon dioxide. The case had some success at the trial level. It went back and forth to the Intermediate Appellate Court and the Supreme Court and the trial court, but ultimately the U.S. Court of Appeals for the Ninth Circuit, by a vote of 2-1, said the case cannot proceed. The court said that the plaintiff, it agreed with the plaintiffs that climate change is a terrible problem, that humans are mostly causing it, and that the U.S. federal government played a role. But the majority opinion concluded that the plaintiff's case must be made to the political branches or to the electorate at large, and that the courts may not become the decision makers here. There was a very strong dissent from one of the judges, but the Ninth Circuit majority ruled the case cannot proceed. The plaintiffs have now made a motion to the trial court to amend their complaint, and instead of seeking an order that the federal government reduce its emissions and do all these other things, just seeking a declaration. So we're now awaiting a decision by the trial court, and whatever it decides will no doubt be appealed. There's also an emerging line of cases alleging failure to adapt to climate change. An NGO in Boston, the Conservation Law Foundation, has brought several lawsuits against fossil fuel companies, not because of their fossil fuel emissions, but because alleging that their oil tanks are vulnerable to storm surge and other climate worsened events, and that the companies have not taken adequate precautions against the risk that these oil tanks will burst and cause a massive oil spill. So these cases are proceeding, and we're seeing other failure to adapt cases. So I'm going to now turn it back to Maria Antonia and just say that, as you see, climate change litigation has long been a very active source of cases in the US, and we're now seeing its emergence throughout the world. Thank you.
Thank you very much, Mike. I'd like to invite now Dr. Judy Rogers, who is the Director of Research at the Grantham Institute, Climate Change and Environment, and one of the lead author in the IPCC reports, to talk a little bit about the science that informs the cases.
Yeah, thank you very much, Maria. Thank you very much for the invitation to present here at this really timely and important workshop. In the short time that I have available, I will be covering some of the climate science insights that can underpin climate change litigation. And I will be doing so mainly from what we call Working Group 1 perspective. And Working Group 1 perspective is the Working Group 1 of the Intergovernmental Panel on Climate Change, the UN body that assesses regularly the state of the science in the physical science basis, the impact and adaptation, and then the solutions to climate change. I was a lead author on this report, and also on the 1.5 degree special report that was published in 2018. I want to highlight some of the key insights of this report, basically linked to what we know scientifically about the historical responsibility of humans in causing climate change and in contributing to extreme events and disasters, our scientific understanding of what is needed for halting global warming at any level, be it at low and ambitious levels or at high levels, but simply to halt warming. And then also reflect on some of the intergenerational and international fairness that draws from these climate science insights, basically reflecting on the impact of how decisions today affect projected climate change and how efforts can be shared between and within generations. As I said, I will be drawing on this report of the Intergovernmental Panel on Climate Change because not everybody might be familiar with these reports, or maybe with the reports, but not necessarily with the process that is behind these reports. I just want to highlight the incredible effort that goes into this. These reports are written over multiple years by international author teams. This particular report was written by 234 lead authors from 65 countries. We assess more than 14,000 publications. These reports go through both expert and government review rounds, where we receive over 80,000 or about 80,000 comments, to which we each respond in writing individually. And finally, the summary of these reports gets approved sentence by sentence in approval plenaries of the Intergovernmental Panel on Climate Change, where the 190 plus members of the IPCC approve the accuracy of each individual sentence of that summary. I just want to highlight this to show kind of the well-established nature and the incredible robustness with which these statements can be made by the IPCC. The first statement I want to draw your attention to is that recent changes in the climate are widespread, rapid, and intensifying, and unprecedented in thousands of years. And the high-level summary of that report has a really nice visual illustrating that. I was warned that the audience would be mainly lawyers, but I hope that the visuals will not scare you away, the technical visuals, but on the contrary, can really increase your confidence in the robustness and in the strong understanding that we have, and in the high level of confidence that we have. Here on the left-hand side, you can see simply a reconstructed and then a actually observed temperature record over the past 2,000 years. And what you can see there is that the warming that we are experiencing today, let me pull up my laser pointer, for the last 150 years is absolutely unprecedented in the last 2,000 years. And if we just look at the rate, it is even unprecedented in many hundreds of thousands of years. On the right-hand side, you can see an illustration of our best understanding of the contributions of humans to this warming. In green, around the zero line, you can see the climate evolution that would be projected if we only take into account natural forcing, changes in solar intensity, volcanoes, and so on. And you can see that is not at all corresponding to what we observe, which is the thin black line. Only if we take into account human and natural causes or forces, we can actually explain what is being observed. The most important greenhouse gas that contributes to this is CO2, closely followed by the impact of methane. The IPCC can also say that it is indisputable that human activities are causing climate change, making extreme climate events, including heat waves, heavy rainfall, and droughts, more frequent and severe. And this is illustrated in this visual here. I can't go into too much detail, but basically what you can see on the right is kind of a stylized visualization of the globe and of our planet. Every hexagon that is colored red is a region where the increase in hot extremes can be attributed to human activities. So it is not only that we have observed that hot extremes are increasing in those regions, but we can say that human activities are one of the causes that contribute to this. And as you can see, it's basically pretty much over the entire globe, we can attribute the increase in hot extremes to human activities. Similar evidence is available for droughts or for heavy precipitation. And if you go to these reports, you can see them there, but you can see that for precipitation or rainfall and for droughts, the image is a bit more patchier. So heat extremes is a very clear climatic impact that can be linked to human activities, where droughts, not in all regions, can be clearly linked to human activities or to climate change, simply because the year-to-year variation is much larger and the signal has not yet emerged from the noise in all cases. Climate change is already affecting every region on Earth in multiple ways, and the changes we experience will increase with further warming. There is a lot of evidence on this in the underlying report, but there is one visual that I want to highlight in particular. In this visual, and particularly if you look at the right-hand side of the visual, it shows how temperature extremes will change over time and will change with each increment of global warming. If we look here on the right-hand side, you can, and this represents a 1 in 50-year event, a heat wave that, for example, our great-grandparents that lived from 1850 to 1900 would have experienced once in their lifetime in this period. Already today, this event is occurring once every 10 years. And if we increase warming further, or if we let warming increase further, for example, until 2 degrees of warming, an event that our great-grandparents experienced once every 50 years will be experienced on average once every 4th year. So this really just highlights how our concept of extreme will drastically change and how global warming will really affect the number and also intensity of extremes that we will have to deal with. In many cases, there is no going back from some changes in the climate system, but some changes could be slowed and others could be stopped by limiting global warming. And this is something that this is a statement that really needs to be kept in mind. There are some changes that our current emissions, our past and present emissions, have already put in place, and that will never be reversed. These are changes, particularly to the slow changing components of our Earth system, including ice sheets, sea level rise. Other changes could be halted, but even then would not be reversed. And I would want to illustrate this with 5 scenarios, 5 potential futures for our planet. Of course, in this case, these futures are illustrated by simple lines on a graph. Here on the left-hand side, you can see our 5 different futures of global emissions. One future where emissions become extremely high. This basically involves a rollback of current climate policies and a recarbonization of our energy system. Not extremely likely, but also not impossible. On the very low end, that is a world where we halve our emissions by mid-century, by 2030, and we reach net zero CO2 emissions roughly around or in the 2050s. So that might be one of the most ambitious climate mitigation futures. Now, on the right-hand side, you can see the corresponding temperature outcomes of those different pathways. On the high end, you can see global warming exceeding 4 degrees by the end of the century. For the 2 lowest scenarios that reach net zero CO2 emissions and go even net negative thereafter, you can see that global warming in terms of temperature increase has been halted over the course of the century and even gradually is gradually reversed towards the end of the century. That reversal is because these scenarios actually actively remove carbon dioxide from the atmosphere in the second half of the century. And that, given our best understanding today, would result in gradually reversing warming. Again, as you can see, even when we reach net zero CO2 emissions, which for example, here is in the 2050s, global warming doesn't disappear. It is merely halted. We are not making it any worse, but what is committed through historical emissions stays there until we actively have removed the excess CO2 from the atmosphere. This is for global temperature, something that is very much in the media and that we have a kind of a clear view on. However, if we now look at some other components of the climate system that equally change, we see that not everything is halted over the course of the century. This image now shows sea level rise. Sea level rise until 2100. And what you can see here is that even for those scenarios where that reach net zero CO2 emissions and for which temperature increase has been halted, sea level rise will not have stopped by the end of the century. Sea level rise will progress slowly but surely, even in the lowest emission scenarios. It will progress more slowly than in the high emission scenario that's reached 4 degrees, but it will progress nevertheless. And it will progress for many centuries, because if we put this in context of in a centennial context, and this is what my next figure does, this small panel here is the same as I showed before, but now it's so tiny because I put on the right-hand side the sea level rise that we would see until 2300. Of course, if we don't reduce our emissions, we see massive amounts of sea level rise, up to 7 meters and more in 2300. But here, this low blue bar at the bottom shows what we would get even if we limit warming to 2 degrees. And you can see that this entire blue bar is much higher than what we would see until 2100. And that is irrespective of us actually having stopped warming at 2 degrees. It is this baked in melting of ice and expanding of sea as a result to the warming that results in this gradually further increase in sea level rise. Next, let's have a look at the solutions. To limit global warming, strong, rapid and sustained reductions in CO2, methane and other greenhouse gases are necessary. The good or positive message is that it would not only reduce the consequences of climate change, but also improve air qualities and therefore have a direct impact on public health, on local public health even. The key visual of the IPCC report that supports this understanding is the following. This time on the horizontal axis, we don't show time, but we show the total amount of carbon dioxide emissions that have ever been emitted into the atmosphere since 1850. Every ton is just added up to the previous one. On the vertical axis is again global warming. And what you can see here is that there is a near linear relationship between the total amount of carbon dioxide we have ever emitted into the atmosphere and global warming. And you can see that here for observed quantities in gray, so observed or estimated historical emissions and observed historical warming, as well as for the 5 scenarios going into the future. And as you can remember, these scenarios were drastically different from very high to very low emissions. Yet in this area where we look at cumulative emissions versus total warming, they all fall pretty much on the same line. And this near linear relationship and this very strong near linear relationship underpins our understanding of there being a carbon budget. There is a total amount of CO2 that we can ever emit if we want to limit warming to 1.5, 2 degrees, or any other level. For example, in this case, if we want to limit warming to 1.5, we can read off here on the horizontal axis how much the total amount of carbon dioxide is that we can ever emit. And fortunately, we don't have to read off from this graph, but the IPCC has actually produced a table where these carbon budgets are being provided. There are a few interesting aspects or interesting pieces of information in this table. First, the historical warming, we have warmed the planet now by 1.1, 1.2 degrees, is basically driven or basically caused by the totality of our historical emissions, around 2,400 billion tons of CO2 that we have emitted. If we want to limit warming to 1.5, 1.7 or 2 degrees, and any of those limits that are there in the realm of what the Paris Agreement tries to achieve, just to be sure, the Paris Agreement aims to limit warming well below 2 degrees and pursues to limit it to 1.5. And so the carbon budget consistent with those levels are given here below, what you can see here in this table. For context, limiting warming to 1.5 with a 1 in 2 chance gives us a carbon budget of 500 billion tons. Today, we are putting roughly 40 billion tons every year into the atmosphere. That means this carbon budget would be exhausted in roughly 10 years, give or take a few years. Put differently, if we want to stay within this carbon budget and start declining global emissions today on a linear trajectory, we would need to reach net zero global CO2 emissions in about 25 years. Now, how well are we doing? Another annual report I am involved in is the UNEP emissions gap report. Every year, we there look at where emissions are heading based on current pledges and where they should be going to limit warming to 1.5, 1.8 or 2 degrees. And that is what is shown here. You can see that between the pledges, NDCs or nationally determined contributions under the Paris Agreement, and either a 2 degree or a 1.5 degree pathway, there is still a very large emissions gap between what countries are pledging and where we should be going. So we are very far on the global level from limiting warming to the goals that are set out by the Paris Agreement. The challenge, of course, is to translate this from the global to the national. And for this, we need to use various principles, or the literature uses various ethical or legal principles to translate a global goal to a national goal. And one example of how this can be done is done by Climate Action Tracker, which rate the targets that countries are setting or submitting under the Paris Agreement on whether they are, let's start here on the right, Paris 1.5 Paris Agreement compatible, almost sufficient, insufficient, highly insufficient, or critically insufficient. And as you can tell from the colors on this graph, there are very few countries that are actually 1.5 degree Paris Agreement compatible. Some countries are almost sufficient, but most of them are insufficient, with several ones being highly insufficient and critically insufficient. This judgment, of course, can only be made when we compare the relative contributions of countries, and we consider also aspects of fairness and effort sharing between countries. Finally, to conclude my input here, the best available science, as assessed by the IPCC, now supports the attribution of global warming to past and present human activity, the attribution of individual extreme events to past and present human activities, the projection of near and long-term climate change as a function of our decisions today, and also clearly spells out the requirements for halting global warming, which include limiting our total emissions within a carbon budget and reaching net zero carbon dioxide emissions globally. And with that, I would like to thank you once again for the opportunity to present at this conference, and I look forward to the discussions.
Thank you very much, Professor Rogers. This is excellent. Gives us a very good sense of what we're dealing with. I'd like to invite now Professor Linda Sulistyawati, who's a Senior Research Fellow at the Asia Pacific Center for Environmental Law at the Faculty of Law at the National University of Singapore, who's also a lead author in the IPCC reports.
Thank you, Maria. I would like to share my screen now. Okay. Okay, can you see my PowerPoint?
Yes, we can.
Okay. Whoops. Okay. Okay, good day, everybody. It's already nighttime in Singapore, but I know it's morning in Sabin Center and also maybe in another time zone. So I would just say good day because I don't know where you are. Thank you very much for Sabin Center and the UNEP for the invitation to this very esteemed event. I hope I can contribute as requested. And thank you for Joanna Setzer. With the spirit of IPCC, she peer-reviewed the PowerPoint that I made just to make sure that it already included everything that is said in the IPCC report. So just to complete what Dr. Judy Rogers already explained to us earlier, IPCC was founded in 1988 by the World Meteorological Organization and UNEP. And since then, we have already had 6 assessment reports and 3 special reports. And our last one, the one that was partially explained from Working Group 1, was the Assessment Report 6. And Dr. Yuri was in Working Group 1 and I'm in Working Group 3, which is mitigation. So he's on the science and I'm not. I'm a legal scholar, just like probably most of you are. So the role of IPCC, ladies and gentlemen, is to assess on a comprehensive, objective, open and transparent basis the scientific, technical, and socioeconomic information relevant to the understanding of the scientific basis of risk of human-induced climate change, its potential impacts, and option for adaptation and mitigation. IPCC reports should be neutral with respect to policy, although they may need to deal with objectively scientific, technical, and socioeconomic factors relevant to the particular policies. So this was also already explained earlier, but this is just to give you an idea of how we work. We have 3 working group: Working Group 1 on science, Working Group 2 on adaptation, impacts adaptation and vulnerability, Working Group 3 on mitigation of climate change, and then we also have a task force on national GHG inventories. In the government side, we have the plenary of where government representatives are, and then the bureau and executive committee that oversee all the operations that are done within the organization, within IPCC. And as already discussed, like one report can take 200 plus authors, scientists, review editors, and expert reviewers. And all of us are volunteering our time for the IPCC. So when you hear lead authors or contributing authors for the IPCC, we are with all our understanding, we are volunteering our time for the effort that is done by the organization. So this was what we have in our AR6 mitigation working group 3 summary for policymakers. So this figure echoed what the working group 1 of IPCC already explained earlier, that the global net anthropogenic emissions have continued to rise across all the major groups of GHG. Of course, as legal scholars, as lawyers, we can see, what we can see is like how all these lines are increasing from 1990 until 2019. So how about the nexus between human rights and climate change? So in the AR6 that was produced by Working Group 3 just earlier this month, launched this month, it was acknowledged that the issue of human rights and climate change, specifically the linkages, was first taken up by the UN Human Rights Council, HRC, in 2008. But since then, it has gained ground with the UN Human Rights Treaty bodies, issuing comments, recommendations, and even joint statements on the impacts of climate change and on the enjoyment of human rights. So it has became like a joint understanding that, you know, this issue between human rights and climate change, specifically climate impacts, has impacted policy making. So this is what we highlighted in the assessment report 6, specifically Working Group 3, that climate change effects and related disaster have the potential to affect human rights broadly by giving rise to deaths, rising diseases and malnutrition, which is right to life, right to health, threatening food security or livelihood, which is right to food, impacting upon water supplies and compromising access to safe drinking water, which is right to water, and destroying coastal settlements through storm surge, the right to adequate housing, and in some cases, forcing relocation as traditional territories become uninhabitable. So in addition, the right to healthy environment was recognized in 2021 as an autonomous right at the international level by the Human Rights Council, arguably extend to the right of safe climate, shaped in part by the Paris Agreement. We can see here, this also is discussed in our report, that the Paris preambular recitals on human rights recommends that parties, when taking action to address human rights, take into account their respective obligation on human rights. First, for an environmental treaty. So you see here on the bubbles, the first bubble and the second bubble, this is actually not, you know, not an exhaustive list, but this is what we have found in the preambular of the Paris Agreement. You see here the right to life, right to health, right to development, right to an adequate standard of living, right to food, including clean water and sanitation, and then right to housing, right to self-determination, including as applied for Indigenous people, and the right to a healthy environment. In addition, climate impacts contribute to displacement and migration and have disproportionate effects on women. Here's another graph figure that is taken from the Summary of Policymaker on Working Group 3, Assessment Report 6, that projected global GHG emission from NDCs, the nationally determined contributions, prior to COP26 would make it likely that warming will exceed 1.5 degree, as Dr. Yuri explained earlier, and make it harder after 2030 to limit warming below 2 degrees. So I guess this slide would, you know, frame what will be discussed, you know, within the next 2 days in your conference, in our conference. It's the nexus between human right, climate change, and climate change litigation, right? In our report, we highlighted that as the intersection between climate impacts and human rights become increasingly clear, litigants have begun to use human rights argument with a growing receptivity among courts towards such arguments in climate change cases. Right? Some already mentioned by Michael earlier, that there's this Urgenda case in the Dutch Supreme Court, which interpreted European Convention on Human Rights in light of customary international law and the UN climate change regime, and ordered the state to reduce GHG emission by 25% by 2020 compared to 1990. And then in Germany, we found the Neubauer case in 2021 in light of its obligation, including on the rights of protection, to set clear provision for reduction target from 2031 onwards by the end of 2022. And then in Nepal Supreme Court of 2018, the decision in Shrestha ordering the government to amend its existing laws and introduce new consolidated laws to address climate mitigation and adaptation, as it would protect the right to life, food, and clean environment, and give effect to 2015 Paris Agreement. And there are over 100 further cases in national and regional courts based on human rights claims, and this trend is only likely to grow. And we have this cited from several studies that are already published. So when we see these cases, I saw there's one question asking whether, class action litigation can use science that are documented within the IPCC report. It depends on, the national, your national system. If your national system can adopt class action, and IPCC report would surely be part of your information to use. But whether it is, a legal instrument, I think you have to go to, the international agreements or international law that is already there. But in terms of national courts, the UNEP's Global Climate Litigation Report, launched in 2020, noted that between March 2017 and July 2020, the number of climate litigation cases nearly doubled. And this report still cited 1,550 cases, but earlier Michael have said that it's close to 2,000. It's like 1,900 now. So environmental courts and tribunals would be better equipped to handle this phenomenon. Their mandate, independence, procedures, resources, and court support should be ready to handle the surge of environmental cases. However, many environmental cases in countries without environmental courts or tribunals are assigned to general courts, right? But the current trend shows that countries are training their general court judges with environmental law issues to have them familiarized and capable to handle environmental cases. So even though they're sitting in a general bench, but we call it the green bench because these judges are familiar with environmental law cases. So what was highlighted in the IPCC report then? For the first time this year in AR6, the IPCC assessment report has recognized that there is now sufficient evidence that climate change litigation has influenced the outcome and ambition of climate governance. The full report of AR6 dedicate some subsection to climate litigation, and also in chapter 1, chapter 13, chapter 14, climate change and human rights and climate cases are highlighted. So I think I'm going to stop here, and maybe we have summertime for discussion. And yeah, so I'm very grateful that I have the time to share this with all of you. And I hope we have fruitful discussion, not just this panel, but also for the next 2 days. Thank you very much.
Thank you very much, Professor Sulistiawati. I'm sorry. We appreciate your contribution, and it's definitely very significant that the IPCC report did note the role of climate litigation in helping reduce emissions and contribute to mitigation efforts. So I would like to ask the panelists now if you have questions for one another. There's some in the Q&A, and I do have some questions as well, but I'd first like to extend the opportunity to you if you wanted to ask each other any questions. Right. So maybe I'll start with a question to Dr. Yojo. There are a lot of cases now that do rely on this notion of fair share and on the different carbon budgets to each country. So I was hoping that you could talk a little bit about that and the way that that's calculated and how that helps frame some of the contribution of each country to reducing emissions.
Yeah, that's right. And it's almost kind of a monthly request in my inbox that someone asks me, can you help me with the carbon budget for either this country or this organization or so, and that is a challenge, because the concept and the quantification of a carbon budget at the global level is quite straightforward. But even at the global level, it already depends on some value judgments and some choices. For example, you need to choose simply which temperature level you want to limit warming to, but also what likelihood you want to have that warming is effectively limited to that temperature limit level. Is it 50%, so 1 in 2 chance that you're successful, or is it more? Is it 66%, 90%, 99%? Well, if you go and do these high probabilities, the carbon budget is very small. But so these are there's a clear set of value judgment and choices that need to be made even before we get to a carbon budget at the global level. Translating this to the national level then involves an additional step or several additional steps that also all rely on value judgments and choices being made first. And an example here is well, there is a broad literature on this, explaining several of the principles that are being used to translate this global carbon budget to national or company carbon budgets, actually more so to national carbon budget than to company carbon budgets. And they rely on principles of equality, historical responsibility, capacity to reduce, the level of development, the right to develop, and these kind of things. And these can be combined in different ways, subjective ways, which however can be argued into a means and to translate them to national budgets. The experience that I had in, so I wrote kind of a scientific supporting briefing for but it was not a case, but it was a petition to the UN Committee on the Rights of the Child for that kind of that indicated that for 5 G20 countries that they were doing insufficient action to guarantee the rights of the child or the right for a safe life. And what we did there is, instead of picking one way of translating the global carbon budget or the global effort to countries, we took several ways that kind of spanned the views of the literature. And fortunately, in each of these cases, the targets or the ambition put forward by the countries was not consistent with any of the potential ways in which the global burden could be split up to the national level. So in that case, it's quite easy to argue that a country, irrespective of how you split it up, is not doing enough. But in other cases, this might become quite difficult, particularly in the context of developing countries, where there is an important question to be asked whether there is such thing as the right to emit or the right to cause damage once we know that CO2 is causing damage.
Thank you very much. That's very helpful. Professor Gerard, I was hoping you could talk a little bit more about, there were a couple of questions on the role of science in the climate litigation cases. So maybe you can talk a little bit more about climate attribution and how that has been playing a role in the litigation cases.
So in few, if any, of the decisions of the United States or indeed around the world, have the courts cast doubt on climate science. They generally accept the scientific consensus, and the decisions that have thrown out cases have overwhelmingly been just on legal grounds. They have ruled that it is not for example, that it is not the role of the courts to make decisions about what to do about climate change. That's the job for Congress and EPA and other administrative agencies, or parliaments and governments in other countries. So none of the cases really have gotten so far as to address the attribution science. If the US cases brought under state common law theories survive all of these legal questions, then they may get to that, but they haven't yet. There is a fair amount of discussion of scientific issues in the Endangered Species Act cases on whether there's been established a real threat to certain species as a result of anticipated climate impacts. And there the courts have again accepted the climate science, but the sort of attribution science that we've been talking about could well become important in some of these cases. The Juliana case tried to bring that forward, but so far they really have not played much of a role in the actual litigation. There have really only, I believe there's only actually been one trial in the US in which climate science was actually an issue. That was back in around 2007 in a case in Vermont about motor vehicle standards, and the climate science was upheld in that case.
Thank you. Professor Sulistyawati, you mentioned the recognition of the right to a healthy environment by the Human Rights Council, and how that is now being considered by the General Assembly. Could you talk a little bit more about that and how that could impact climate litigation?
Yes, thank you. So the right for a healthy environment is actually very important once we think about how it is the umbrella to other rights, including the right to housing, the right to clean air, the right to clean water. Even when we think about, even the right for future generations, etc. So, these other rights that are connected to one another under the right to safe of environment would, it would be like a greater argument that can be used for cases nationally. I think, as we have seen in many cases all over the world that has been using, like Juliana, like Urgenda, also trying to like pull up on the right of future generation. But also, we have seen cases that couldn't get through because the idea was so abstract. But now that the UNGA has already acknowledged the right of safe environment, suddenly there's a bridge that can be crossed, by all these other rights argument that would give us more ground to stand on. So I think it's groundbreaking that, you know, the UN itself has already given its approval. Then, you know, judges all over the world would have to acknowledge that, you know, that the General Assembly themselves has already acknowledged the importance of the right of safe environment.
Thank you. Professor Gerard, you talked a little bit about the issue of regression in the Trump administration and how there was some backlash in some of the regulations and how now that's being, some of these policies are being put back in place by the Biden administration. I was hoping you could talk a little bit more about that, and also the recent announcements on increasing fossil fuel production, considering the geopolitical momentum that we're currently at by the United States, and how that could impact climate litigation.
The decisions striking down the efforts by the Trump administration to move backwards on climate regulation were almost entirely on procedural grounds. The administration was frankly very sloppy in doing the necessary studies and disclosures and comment periods and so forth. Had President Trump won a second term, his administration might well have been able to go back and fix those procedural errors and then survive the inevitable litigation. So the courts in throwing out many of the Trump administration's actions were not applying a principle of non-regression. Really, they were it was on strict procedural compliance. Now, as you allude, and given the current Russian invasion of Ukraine and the consequent energy crises that is leading to, we're seeing moves by the Biden administration to open up more land for fossil fuel production, more accelerated construction of liquefied natural gas facilities and so forth. And the Biden administration is doing that because it is facing enormous domestic pressure over inflation. That's the principal domestic issue that they have, and they are saying that this is a way to address that. It won't really. It'll be several years before any of these new fossil fuel production facilities are up and running, and even when they are, it'll be such a small contribution to global crude oil supplies that it won't have much effect on the price, but it's being done for these political reasons. There may be some challenges to some of this, on procedural grounds. There may be some arguments that there wasn't adequate environmental analysis under the National Environmental Policy Act, for example. We'll see how that litigation plays out. The administration and defense will claim that, will say there's a such a national security crisis that they need to proceed with these plans. But again, the principle of non-regression is really not played out in these cases.
Thank you very much. Dr. Rogers, I was hoping you could talk a little bit about the role of countries in the Global South in mitigation efforts.
Their role is enormous, and their role is different from what we see in developed countries, but equally incredibly important. So their role is important because in many cases, they have not yet built up the infrastructure, the polluting infrastructure that powers economies in more industrial parts of the world, and they can thus make choices that avoid lock-in into that polluting infrastructure. It is generally understood that everybody has the right to develop. And the right, and that right, I don't think is anywhere being discussed or questioned. However, for a very long time in the literature, the right to develop was kind of was held was put on the same level as the right to emit CO2 emissions, because in the past, over the past century, development was very strongly and pretty much uniquely correlated with how much CO2 emissions for energy you were able to emit. Now, the literature and the scientific evidence shows that what is necessary for development is energy. It is not CO2 emissions. And therefore, what is really important for developing countries is to achieve the or to meet the energy demands of their population, first to leave poverty, and then to also further develop, but to do that in sustainable and clean ways. And of course, in many cases, this involves investments, quite high upfront investments. And these investments, their developing countries can, of course, be supported by developed countries. And there is a good example, for example, in South Africa, where during the last climate summit, COP26 in Glasgow, there was basically a package deal with South Africa and several developed countries that where developed countries pledged for funding and finance for South Africa to basically shut down its coal-fired power plants and to make a kind of fast transition towards a low carbon economy. And I think these kind of partnerships are absolutely necessary for developing countries to also make the turn and go on to a declining emission path. Just to be sure, again, from a global perspective, to stop warming from further increasing, global CO2 emissions need to get to net zero. So there is only a limited amount of ways in which that can be achieved, or there is limited flexibility. There's infinite ways, but limited flexibility. And so in all of those cases, that involves also strong reductions in developing countries. It could be that developed countries, if they are able to do so, could actually go into net negative territory, and that means that they would not stop at net zero emissions, but would actually, on average, in 1 year, remove more CO2 from the atmosphere through their activities than they are emitting into it, and with that they would allow for some remaining emissions in developing countries, while globally reaching net zero. However, that potential is limited. So in all cases, emissions in developing countries can't follow the development trajectory that we have seen in other parts of the world over the past century. And they also don't have to, because today we have the options to avoid such trajectory.
Thank you very much. Professor Celestawati, can you there was a question here about the role of multinational corporations, especially in developing countries. So can you talk a little bit about that from a human rights perspective and sort of this extraterritorial responsibility as well?
Yeah, so thank you, Maria. Just call me Linda, it's fine. I think this comes up a lot when we're talking about, the power balance between MNC and developing countries. Even when we did surveys and, talked to governments of developing countries, in Asia Pacific, it's clear that, there are like pressure points where they feel like, not very confident when they're faced with MNCs, considering these MNCs are very strong and, globalized and maybe have more leverage in terms of politics and economics and, what have you, against governments. But really, when we are talking about environmental and international law and human rights, we see like all the instruments there are favoring states or just focusing on the role of states. So government should not be afraid. I think they should be confident, because these instruments are backed up by international organizations, and also stronger states are giving them also support. Just an example, like the international supports that are spelled out in Paris Agreement, for example. The financial support is there, like they are giving political push, even though even though it hasn't materialized yet, but the promise is there. So government with less sources would be able to, I think, work together either regionally or internationally in terms, to push their, adaptation efforts and mitigation efforts. And we've seen this in the Pacific, we've seen this in Asia, I suppose, and how they could work together regionally, and join forces. And these MNCs are, currently, there are research that have shown, like some of them are also very environmentally aware that they need to reduce GHG. Even the Organization for Petroleum Exporter Countries also understood that, this GHG emission cannot go berserk and increase all the time. So like most of us already aware what's going on, we just need to like sit together and really do more, because we already promised with our NDCs, but these NDCs are not adequate to push the temperature down for well below 2 degrees. I think that's the highlight.
Can I just add a thought to Linda's excellent comments? Many multinational corporations, of course, are making these net zero pledges, but they're not defining them. They're not saying what it means, whether it just applies to their direct emissions or to the effect of their fossil fuels. But just a few weeks ago, the U.S. Securities and Exchange Commission issued proposed regulations which would require U.S. corporations to back up their net zero pledges, say exactly what they mean, and hold their feet to the fire. We may see emerging requirements along those lines in other parts of the country, in other parts of the world. And to the extent that happens, that I think will be an important mechanism for accountability of these companies, because if they're making these pledges, they're really going to have to explain them and then carry them out.
Yeah,
so I think that can make a big difference.
I agree. Thank you.
Thank you very much, Professor Gerard. And I think we have time for maybe 2 more questions. So Professor Gerard, can you tell us a little bit more about the role of state constitutions in the United States as well?
So, of course, each of the 50 states in the U.S. has its own constitution, and a few of those constitutions include environmental rights provisions. I mentioned that one of the cases brought by Our Children's Trust, the one in Montana, is set to go to trial in February of 2023. That one is based on an environmental rights provision in the Montana state constitution. The voters in New York State this last November added an environmental rights provision to the New York State Constitution. It said that there is a right to clean air, clean water, and a healthful environment. We'll see how the courts interpret that. There are also provisions of the constitutions of Pennsylvania and Hawaii on environmental rights. So these are purely matters of state law, and therefore it's not something that the US Supreme Court can really interfere with. There's a tremendous concern, of course, in the US. We have a 6-3 conservative majority on the Supreme Court. This conservative majority has become fairly aggressive in striking down administrative action. So it's sort of an overhang over much of the US litigation, but the state litigation under state laws is not subject to that. So even if we're not seeing favorable developments at in the federal courts on these theories, we may begin to see more favorable developments in some of the state courts, and doctrines may emerge that actually could be helpful in other countries as well.
Thank you so much. And Dr. Rogers, I think we have two questions here. I'll just combine them to see if there's time to answer both. One question related to the role of gas as a transitional fossil fuel, whether that's something that the IPCC would support given the methane emissions risk. And the other question was on the role of science on adaptation, since a lot of it focuses on the mitigation needs, so whether the IPCC could also help sort of track adaptation needs and improve our ability to evaluate and assess lack of progress on adaptation as well.
Yeah, great questions. On the methane question, or rather the natural gas question, for a long time, natural gas has indeed been seen as a bridge fuel. But for a long time, and particularly the time that message or that idea comes from, we were only aiming to limit warming to 2 degrees. Now the Paris Agreement has a more stringent goal to limit warming well below 2 degrees and pursue to limit it to 1.5. And in these contexts, the natural gas sees a really clear declining trend. In the few cases, or in few kind of hypothetical scenarios where natural gas plays an important role, it is very much conditional, and it's fully conditional on leakage being eliminated. So no leakage from methane or natural gas operations, as well as the successful and economic upscaling of carbon capture and storage, where the CO2 that would be produced by the combustion of that methane is not released into the atmosphere, but actually captured, transported in big pipes, compressed and stored underground. And that is a big condition on methane or natural gas being considered as a real transition or bridge fuel. Otherwise, scenarios also show a clear phase out of natural gas towards the middle of the century. It is slower than the phase out of coal, which is really precipitous, but there is definitely nothing like a revival or a sustained use of that. On adaptation, I think it's a really good question. I think one of the reasons that there wasn't too much said about this is that the two authors that are here are for the physical science and the mitigation reports of the IPCC. There is a third report on impacts and adaptation. So there is the IPCC definitely looks into that. The key challenge, but it is a really important aspect, because the key challenge with the attribution of climate impacts to historical emissions does not only depend on climate change and extreme events being caused by human activities or by global warming. Disaster and losses and damages also depend on whether societies and infrastructure are exposed to that impact and how vulnerable they are. And these two aspects, they derive very often from planning decisions that date back multiple decades or sometimes centuries. And of course, vulnerability of populations depends on sometimes the strength of local institutions, the strength, the levels of corruption, the level of development. And so there is an important challenge to go from the physical climate change and the physical climate extremes down to the losses and damages that these cause because of those additional socioeconomic factors that are layered on top. But all of these are actually assessed by Working Group 2 in the Working Group 2 report of the IPCC. I can pop a link into the chat if you want.
Thank you. That'll be helpful. All right. Thank you very much for answering the questions and for your wonderful presentations. That was incredibly helpful, and it was really great to sort of set the scene for our discussions to come. So we'll start panel 2 now on climate litigation and human rights, and I will move over to our moderator, Dr. Linnea Nordlander from the Center for International Law and Governance at the University of Copenhagen.
Okay, thank you so much for that, Maria Antonia, and to all of the panelists in the previous discussion. That was, I think, illuminating for all of us and a great start to this two-day event. As you can see from the program, this second panel is going to be focusing on climate litigation and human rights. And we have the privilege of having 4 of the 5 panelists that were listed in the program, because unfortunately, Professor Ademola Jegede has fallen ill. He's here with us in the Zoom room and will be able to answer some questions digitally, but unfortunately won't be able to participate. Before we get started, I would like to remind everybody that of some housekeeping rules. So we are recording this panel, so please bear that in mind. And also, of course, as usual, we know this by now, but please keep yourself muted when you aren't speaking to keep disturbances at a minimum. And for the audience, please do write your questions in the chat throughout the discussion, and I'll keep track of them and try to raise them as we go through the discussion later. The format is as follows. Each of the panelists will get about 5 minutes to speak to present their jurisdiction and their area on climate change and human rights litigation. And then that will be followed by a discussion moderated by me, which will of course include the audience Q&A. So I think I'll introduce all of the speakers at once so that we can have a rapid succession between them after. But we have the honor of having a judge in our midst today as well. So we have Judge Aisha Malik with us from the Supreme Court of Pakistan. We also have Lorena Centeno-Villa from who is a PhD candidate at the University of Edinburgh in the UK. And then we also have Matt Floro, who is a special counsel at the Environmental Defender's Office in Australia. And then we also have Riccardo Luperini, who is a postdoctoral research fellow in international law at the Sant'Anna School of Advanced Studies in Pisa, Italy. And then, as I mentioned, we also have Professor Jegede with us sort of virtually, and hopefully he'll be able to weigh in written format. But without further ado, I think I'll hand over to Judge Malik.
Thank you. Good evening from Pakistan, and thank you for having me. Pakistan's jurisprudence on environment rights and climate change has evolved through public interest litigation. And these are filed before the constitutional courts, being the High Court and the Supreme Court. As such, our constitution does not recognize any fundamental right to environment or to clean water. However, the Supreme Court and the High Courts have in constitutional jurisdiction declared the right to having a clean and healthy environment, or declared the right to clean water, and even declared the right to a climate capable of sustaining human life through the rights, fundamental rights of life and the fundamental right of the right to dignity. By relaxing the rules on standing and allowing any person aggrieved to approach the court, a right-based approach has enabled the courts through judicial review to scrutinize development projects, to scrutinize works and industry with emphasis on procedures, procedural rights, and of course to see the impact on the environment. Courts have entertained petitions filed by private parties against the established specific industries like stone crushing, cement industry, poultry farms, which are statedly harmful to the environment and have required interference from the regulator, who is apparently not doing its job. Then comes climate change litigation, and there's a shift in focus from these environmental jurisprudence that has evolved over the years to now climate change rights. The same fundamental rights, the right to life and the right to dignity, are invoked once again, but with reference to climate change injuries. And the courts now have taken a more cross-sectoral look into the manner in which these injuries are being claimed, that they should be compensated, and how these rights should be protected. The relief has been carved out in the form of adaptive measures, policy measures, and even at times penalties have been proposed to prevent any further, say, deforestation. Pakistan faces multiple challenges with respect to its fast-growing population of 221 million in 2021 and climate change. Pakistan is especially vulnerable to high temperatures and increased rainfall, which impacts its agrarian economy, which contributes 23% to the GDP and 43% of the labor force. So climate change is an issue. Climate change injuries are brought to the courts, and judges have started to craft and create relief so as to try and prompt the government to do what it's required to do, or nudge the government to encourage policy-making frameworks so as to adapt measures to help mitigate the injuries that are being caused and the losses that are being caused. The courts have used with the help of commissions in aid of their jurisdiction to provide information and data, to look at science, and to recommend policies and measures that can be taken. At times, even instead of deciding cases in the form of a continued mandamus or an implementation bench, the court just continues to look at the issue and keeps prompting the government to see and make sure that it's doing its work. So in a recent case that I'm also sitting on a bench, it involves deforestation in the province of Sindh. And we regularly ask the government what they're doing and then see whether their measures are meeting up to the requirements, to their commitments, and whether in fact it's effective or not. So sometimes this is just a more effective way of ensuring that work is done. One of the cases, of climate change cases, that has gotten a lot of recognition from Pakistan is the Asghar Laghari case, in which farmers came to the court to say that they are deeply affected by climate change and the fact that the government is not implementing its climate change policy and not doing the positive things that it's required to do under the climate change framework. The court took notice of this fact based on the right to life, the right to dignity, and it established a standing committee to sort of liaise between the court and the government, and also to liaise between different departments of the government so that they could all coordinate their efforts. So this is one case that actually brought the climate change narrative into the judicial narrative and introduced this concept so that now we have courts talking about climate justice, climate change injuries, and we have different cases now which are also looking at the climate change aspect of cases, which possibly previously were being done in the form of environmental rights, but now have the actual, narrative of climate change. There are different types of cases. Deforestation is one of them, where the court has taken notice not only in the Margala Hills, but also in the province of Sindh, and has talked about the public trust doctrine, has talked about future generations, and has talked about how the deforestation affects the ecology, the ecosystem, and how it has to stop. In one of the cases, the court actually went to giving directions which required the government to take measures to create awareness, not only through social media, television, but also through schools, and encourage people to grow trees and stop cutting trees. In another case, the court actually directed the government to impose penalties on people who were cutting trees, and even on forest officers who were not doing their jobs. So courts have really taken sort of, charge of the matter to the best of their ability. Of course, the matter has to come to court for them to take charge of the matter, but they have made an effort to try and enter this highly complicated area and try and unfold some of the ways in which it can, they can provide adaptive measures to help Pakistan deal with climate change. Of course, courts have played a very active role, and in that they have prompted the government on many many different occasions. Of course, this is not the only way forward. There have to be other measures. But I think that what is important to say is that the courts of Pakistan are conscious of climate change, are conscious of the fact that adaptive measures have to be taken. There is discussion of water justice, climate justice. There's discussion of intergenerational rights. And there's a lot of discussion of international standards and international agreements, which means that through judgments also a narrative is being built which encourages some action on the part of the government as well as on the part of the regulator.
Wonderful. Thank you so much for that, Judge Malik, for a very quick introduction, but I'm sure we will.
Yes, I was
have the
told
time.
5 minutes, so I tried to keep it brief.
Perfect. But I'm sure we'll have plenty of time to dig into that a little bit more. But for now, I'll hand over to Lorena Centenovia. I hope I'm pronouncing that somewhat correctly. You have 5 minutes. Sorry, Lorena, we can't hear you. Still nothing? Or am I the only one?
You? No?
Now we can hear you. Perfect.
Okay, it's something with my head. Okay, so good afternoon. My name is Lorena. I'm a research PhD student in the University of Edinburgh, but before doing a PhD, I have been working in the court in Chile. So my interest about climate change came when I started to study cases in the constitutional room in the Supreme Court of Chile. So today I'm going to talk like 5 minutes about what is my approach to the human right-based argument on climate change cases. So this is not the main focus of my research, because what I'm trying to do is to research on climate change litigation in Latin American jurisdiction and trying to address or to get an idea how is climate change law developing in this jurisdiction. And of course, human right argument is part of this development. However, even when there are a lot of optimism in the global north or in the academics paper that have been writing about this, in my experience, I have a lot of concerns still on how this is going to work as an argument to solve climate change litigation case. And that is because the experience on Latin American jurisdiction is not really good regarding protection of human rights in extreme crisis situations. So it got to my mind what has happened in Chile, for example, during the dictatorship, and also in other Latin American dictatorship. Most of the constitution of Latin American countries have the recognition of human rights. Latin American countries are civil law system, are money system. So judges must apply international treaties and must apply international human rights. But the experience that have been happening even until now is that it's not the general rule. And there are also a lot of judges that don't apply human rights immediately, and they are expecting to the legal implementation of the treaties. So this situation can also concern me, because the constitutional design of most of the constitution of Latin America, even when they have this recognition, also doesn't implement measures in order to ensure the efficiency or efficacy of the judicial work. And as an example, it's very surprising to see the constitution of Bolivia, that is beautiful and is also poetry. Everybody mentioned that as the one that recognized the right of the Pachamama, also the Constitution of Ecuador. And if we see how many cases of climate change have came from those areas, at the moment in Bolivia, we don't have any case, but for sure they do have some kind of conflict. One thing that may be happening in those countries is like environmental protection is absorbing climate change issues also, but also it can be happening that judges without enough training and litigants without enough knowledge about climate change are not bringing those cases to court. So I think that we can look this argument of human rights as a really good argument in order to fight climate change, but in Latin American jurisdiction, I think as they have like a juridical culture of legalism and extremely formalism, it's necessary to develop a specific law so we can ensure security for all the people. So this is my presentation.
Perfect. Thank you so much for that, Lorena. Now I will swiftly pass on to Matt Floro, if you would like to unmute yourself.
Thanks, Linnea. Can you hear me okay? Very good. Thank you, everyone. It's a pleasure to speak with you this morning or evening, wherever you are. Australia is an interesting jurisdiction because it has the second highest number of climate change litigation cases in court. The US has the highest number with about 1,390 as of July last year. Australia comes in second at 115, quite a smaller number, but then it drops off quite swiftly after that. So we are actually in Australia the second most litigious country for climate change litigation. It's my privilege at EDO, the Environmental Defenders Office, which is a community legal centre, to work on some really interesting climate change cases. I practice in the human rights and coal area at the Environmental Defenders Office, and I have been able to run cases in my home state of New South Wales, where Sydney is, and also in other cases around the country. We are currently running a human rights and climate change case in the Queensland Land Court. Queensland is the third largest state in terms of population, the second largest state in terms of area. It's the home of the Great Barrier Reef, beautiful Cairns, wonderful biodiversity, but all of that is under threat through climate change. This case, which many of you may have heard of, is the youth verdict case. And as I said, that is run in the Queensland Land Court. That case is actually going to start next week. I can't talk too much about it because of confidentiality, but all will be revealed in due course. In summary, in May 2020, our client Youth Verdict lodged an objection to a proposed coal mine in the Galilee Coal Basin in Queensland, which is a massive geographic area with large coal resources. Now, what was unique about this case is that it's the first time in Australia where human rights have formed part of the basis for objecting to a coal mine. Now, Queensland has a Human Rights Act that was enacted in 2019, and 6 of those human rights elements in that act are being used in our case in court. They are the rights of the child, right to life, right to be free from discrimination, the cultural rights of Aboriginal and Torres Strait Islander peoples, the right to property, and the right to privacy. So the case engages all of those 6 points. The defendant is called Waratah Coal. The owner of that company is a billionaire called Clive Palmer, who's very famous in Australia, much less known elsewhere in the world, but he is a large figure within the Australian community. And he's actually got a political party that is running in the upcoming Australian federal election next month. So the company Waratah sought to strike out our client's objections based on the Human Rights Act in Queensland. However, in September 2020, the president of the Land Court in Queensland determined that the court had jurisdiction to consider human rights issues because it was the first time that these issues had been entertained, and declined to strike out. So the case is proceeding next week, as I said. A particular win that we're very proud of is we've been able to obtain orders from the Queensland Land Court allowing for evidence to be given by First Nations people according to First Nations customs. So that is very exciting. The Indigenous peoples concerned for that area of Queensland will be able to give evidence on country, so on their own land. The case will go for 6 weeks before the Queensland Land Court, so very, very exciting. I'd just like to mention that in Australia, we are very, very happy about the UN Human Rights Council's decision on 8 October 2021 to recognise the human right to a safe, clean and healthy environment. And some of our partners around the country are working on trying to get that translated into domestic legislation. So I just thought I'd close on that note. Thank you.
Wonderful. Thank you so much for that, Matt. And now I'll finally hand over to my dear friend Ricardo, if you would like to unmute yourself and give your presentation.
Sure, thank you very much. Well, thank you very much for organizing this amazing conference, and thank you, Linnea, for the introduction. So as a premise, in the network, I'm covering my jurisdiction, so Italy, with my colleague Matteo Fermeia, but today I will deal with the role of international human rights bodies in climate litigation, as I wrote something about that with Arpita Codiveri from New York University, and then I'm now writing a paper on that with my colleague Annalisa Savaresi from University of Eastern Finland. Other colleagues from the network may come back to some of the specific cases or some of the specific systems. And on the other hand, I can, if you want, of course, address some issues about the Italian cases in the following discussion. So in these 5 minutes, I will try to give a general overview of climate litigation before international human rights bodies, and then leave some specific points to the discussion. First of all, by climate litigation before international human rights bodies, we mean individual complaints concerning different aspects of climate change filed with both United Nations human rights treaty monitoring bodies and regional human rights bodies. At present, I count a total of 9 such complaints, 2 before the Inter-American Commission of Human Rights, 4 before the European Court of Human Rights, 2 before the United Nations Human Rights Committee, and 1 before the Committee on the Rights of the Child. We also have communication to UN Human Rights Council special procedures that are included actually in our database, but I will not deal with them here. In terms of the applicants, we have complaints that have been brought by single individuals, by a number of individuals, and also individuals on behalf of groups, like for instance, young people, like in the Saki complaint that I think we will discuss also in the following panel, or complaints brought by indigenous group, like in the groundbreaking Inuit petition in 2005 before the Inter-American Commission on Human Rights, or the more recent Torres Strait Islanders complaint before the Human Rights Committee. Alongside individuals, we also find associations and NGOs, like for instance in the Greenpeace Nordic and Friends of the Earth complaint against Norway before the European Court of Human Rights. As for the respondents, we have states, not corporations, normally one single state as responded, but we also have some, if you want, innovative complaints that address multiple states, like for instance, the Duarte Agostinho complaint before the European Court of Human Rights. Mainly the respondent states are mainly coming from the so-called global north so far, so European state, US, Canada, Australia, New Zealand. Climate change is always central to this type of complaint, mainly mitigation. So the alleged human rights violation are linked to insufficient emissions reduction by the respondent. Adaptation is only dealt with in one case, that is the Torres Strait Islanders case so far. And we also have one important complaint, the Teitiota complaint, that is dealing with, with international protection and the non-refoulement obligation. Human rights are, of course, central to this type of complaint, mainly the right to life, or private and family life, but also the right to culture, intended here as the right of, in particular, of indigenous group to enjoy the benefit of their own culture. We also have then procedural rights, like the right to fair trial or effective remedy for those complaints, for those cases that went through domestic system before reaching the international level. As for the outcome, we have 3 rejected cases so far. So the Inuit complaint that I already mentioned, the Teitiota complaint, and also the Saki complaint that, as I already said, we will, I think, discuss also in the following panel. As the majority of the cases are very recent, we still have 6 pending cases, but it's also important to stress that we do not have a favorable outcome yet. So the first, I think, interesting question might be, can we say that these bodies have disappointed climate litigants so far? Or did they have some other kind of positive impact? All in all, climate litigation before international human rights bodies amounts to a very tiny fraction of climate litigation in general, but also a tiny fraction of human rights-based climate litigation in particular, as this litigation is taking place before domestic courts mainly. So why are these complaints important? Well, it is because of the strategic and high-profile nature of some of the complaints, but also, I think, for the type of forum itself, because international human rights bodies, far from being the perfect forum to address climate change, they still have a very important, large reach, not only legally speaking, but also from a more political and social perspective. So they can certainly play a very important role in climate litigation. So this is the broad picture. Then if you want, we can deal with some more specific aspects in the discussion. So for the moment, I thank you very much for your attention.
Okay, wonderful. So I think that brings us to the end of the formal 5-minute initial presentations. We've had some questions come in the chat, but I'm going to take advantage of my position as a moderator and ask one of my own while I sort of collect and try to organize the audience Q&A. And the question that I would like to ask is a general question for the panel, and it concerns the type of claims that litigants are making in your respective jurisdictions. So are they sort of mitigation oriented, focusing on states in particular or corporations? Are they looking more towards adaptation? Are there any that look at loss and damage? What types of arguments are litigants actually making in these human rights-based cases? Judge Malik, would you be interested in going first?
Sure. So as I said in my introduction, the jurisprudence that has evolved and the cases that come are in constitutional jurisdiction. And generally, the litigants who appear before the courts, sometimes they are affected parties, and other times it's just public interest litigation. It could be filed by an advocate, it could be filed by a resident, a concerned citizen. The complaints are generally, we have few climate change cases. And as had been earlier said, that it's possible that sometimes climate change issues have been absorbed in environment cases, in the claims that are made there. But specifically when looking at climate change litigation, it's generally the claim is a human right violation, a violation of the right to life and the dignity of life by not getting clean water, by the fact that the government is not doing what it could possibly do. So in Asghar Laghari, it was farmers that came to court. In another case, it was a coalition of women who came to court to say that the government was not taking enough action to protect resources and to protect energy within the country, and that this scared them for future prospects. In another case, it was a person who was interested in expanding their business, a cement factory. And their claim basically was that they have a right to do business and a right to their profession, and that the government was not allowing them to expand their cement factory. The area in which they sought to expand the factory was declared as a negative area, meaning it was an area in which the factory could not develop for many environmental concerns. They challenged this, and ultimately when the court ruled against them, the court relied on climate change issues, on water justice, to say that this was a climate resilient policy that was helping the, that was helping to adapt to the problems created by climate change, and therefore this was a good thing, and that they could not expand their factory. So we have a variety of people coming. The claims, because it's constitutional jurisdiction, it's always a fundamental right violation. And because we've been dealing with environment cases since the 90s, we have a very rich jurisprudence on court interference and sort of interpreting the right to life in just about all environment complaints, which is even involves in saving the ecosystem, preventing deforestation, getting clean water, and so on. So I think that constitutional jurisdiction helps the complainant because the jurisdiction is wider. There's more room for the government, for the court to interfere. And then the measures are generally adaptive, focusing on policy initiatives and government responses to see that the right responses are made. So.
Fantastic. Thank you so much for that. Does anybody else want to provide some thoughts on that? Lorena?
Yes, in the Sabin Center database, we have 4 cases from Chile. 2 of those cases are from the environmental courts and arise about legal permits. So those courts are technical courts, like administrative courts, so they don't decide human rights issues. So those cases were more about mitigation, if we understand in that way. And there are 2 other cases that are recently, they are very interesting because they are about just transition. One of them is a constitutional action of protection, how is described in the Constitution. And Chile, as many other countries in Latin America, submit their NDC, and after start the closure of coal plants. So a lot of workers were left without work. So the workers were claiming that the government must to introduce a plan or a program in order to reconvert their activities. So that case was granted by the Supreme Court, and the result of that is that the government is supposed to do like a new policy consulting the workers. And the second case is still pending and is part of other many cases that are coming to the courts now, and is about the lithium extraction. This is about just transition, and in the stage where they are getting the minerals in order to develop the electric cars. So at the moment, there are a lot of claims or discussion, mostly for indigenous people, but also now the civil society is going on that. And those cases are pending in the Supreme Court. But the main argument that they are using is lack of consultation under the 169 of the International Labor Organization, and some others are using argument of just transition, but we don't have a decision of those cases yet. So thank you. Mm-hmm.
Perfect, thank you so much. We also have some contributions from Professor Jagede in the chat, who's saying that in South Africa, the litigation is generally energy-based, and claims seek to challenge actions and inactions of government in relation to commitment to limit global warming under international instruments, and that the claimants use the Bill of Rights in terms of its provisions on the right to environment and the right to just administrative action to found their claims, which is of course very interesting. I also see that Matt has his hand raised. Do you want to unmute yourself?
Yes, Linya. Hari Osofsky, Dean at Northwestern, and Professor Jackie Peel from the University of Melbourne have done a lot of work talking about the typology of different climate change cases. And drawing from their work, in Australia, we have what I think are 3 generations of cases. The first generation of climate change cases in Australia focuses on the environmental statutes, so merits review and judicial review. Obviously, Australia is a common law country. The second generation of cases focuses on private law mechanisms, so looking at corporate misconduct, misleading and deceptive conduct, and private causes of action, for example, the tort of negligence. And the third generation of cases focuses on public law, including human rights. And the chief example of that is the youth verdict case I talked about. Mitigation and adaptation features in each of those generations and will continue to be important, of course.
Perfect. Thank you so much for that, Matt. Ricardo, you also have your hand raised.
Thank you very much. Yes, it was just to answer your question. Well, as for international human rights bodies, the vast majority of the cases deal with mitigation, and in particular the positive duty for the state to reduce emissions to a decent level of ambition, and also the negative duty, I mean, not to cause harm by further, like exploring, extracting oil and gases, for instance, in the case against Norway before the European Court of Human Rights. As I said in my presentation, in my 5 minutes presentation, we only have, to the best of my knowledge, 1 complaint that also deal with adaptation, but together with mitigation. And that is the Torres Strait Islanders complaint against Australia before the Human Rights Committee. But what I think actually that in the future we might see also an increase in complaints about adaptation, because of course, I mean, climate litigants are focusing on mitigation, and this is the priority if you want, yes, sure, but adaptation is complementary to mitigation, and it should be priority, at least I would say, for smaller emitters in the global south, for instance. And also from a human rights perspective, I think that some of the common hurdles that you have in climate litigation, like for instance, causation or attribution, fair share, you have it, I mean, they are there, yes, so in adaptation cases, but they can be lessened somehow. So I think that a human rights approach is also a good one to address adaptation. Thank you.
Perfect. Thank you so much for that, Ricardo. I think I'll turn it over now to one of the audience questions. We have one from Rosario Grima, who asks, climate change has a disproportionate impact on women and girls. Do any of the cases on climate change deal with women's human rights in your jurisdictions? Judge Malik, you mentioned that there was a coalition of women that brought a case in Pakistan. Could you maybe weigh in a little bit on that?
So we don't, to my knowledge, there's no case that has really talked about the impact of climate change on women or girls. But this is a case that was brought by a coalition of women whose essential concern was the fact that there was, again, not enough being done by the government despite policies to respond to climate change. And the relevance of the case is that it was brought by a coalition of women whose concern was the future and whose concern was preservation and what adaptative measures were being taken. So because our jurisprudence on climate change is just it's at the beginning, and I think that one of the biggest contributions of all these cases is really about bringing the narrative into the decision-making, introducing the whole idea of climate justice and, adaptative measures, mitigation. So it's a whole new sort of jurisprudence from the environment jurisprudence. And I think in due time, there are bound to be cases because we have a lot of problems with this extreme weather, with floods, with high rains, which affect women and affect the lifestyles of women, you know. So yes, I expect that in the near future, there may be litigation of this kind, but at the moment we don't have.
Thank you so much for that. Do any of the other panelists want to weigh in on this? Are you aware of any gender-focused litigation in your respective jurisdictions? Lorena?
It's not my jurisdiction because it's Mexican jurisdiction, and it's a like transboundary case because it's about the eolic park in Mexico. It's the case Unión Hidalgo, and that case was brought by Prodes from Mexico, and it's a group of women. And I don't know if the argument used by the court refers to women rights, but the issue was affection to women rights. So it's not very common, but it's starting to grow up.
Wonderful, thank you so much. Matt, you also have your hand raised.
Most of our clients in climate litigation at EDO are women, and we act for mainly community groups in climate litigation, and most of our representatives from our clients are strong women. So that's fantastic to see. An example, not actually a case that we have had carriage of, but Equity Generation Lawyers has run, is the Sharma litigation. Many of you would have heard about that, and the brief moment in time that we had a tort in negligence in respect of the minister, the federal environment minister, owing Australian children a duty of care to protect against climate harm when considering a fossil fuel development proposal. Now, the plaintiffs in that case were a group of young children, the majority of whom were young girls, and the chief spokeswoman from that group was Anjali Sharma, who is a really strong emerging young woman. They won at the federal court, which is a superior court of record that went on appeal. The minister appealed and the minister won. So unfortunately, no more tort there, no more duty of care. But the spokeswoman for the children, Anjali Sharma, put out a really heartfelt media release that said that although there is no legal duty of care, there remains a moral duty of care, and certainly women and girls will be a big part of that.
Thank you, Matt. Ricardo, would you like to unmute yourself?
Sure. So just to comment about the international level, well, at the UN level, we do not have proper individual complaints before the Committee on the Rights of Women, but we have, for instance, an important general recommendation by that committee. It is about disaster risk reduction in a changing climate. At the regional level, we have, for instance, a very important case before the European Court of Human Rights, that is the Klimasignorinen, if I pronounce it correctly, against Switzerland. And in that complaint, the applicant is, well, actually one association, but also individual members of this association of senior women that actually claim that they are their right to life and private and family life is affected in Switzerland, in particular due to climate change impacts, and in particular to heat waves. So this is a very significant case that is still pending before the European Court of Human Rights, but the court communicated the case to Switzerland and gave priority to the case. Thank you.
Very good. Thank you, Ricardo. That was also highlighted by one of our audience members, Natalia Kobilart. I hope that's somewhat correctly pronounced as well. So thank you also for that. We also have two questions specifically for Matt. So one from Steve Lortow, who asks, Australia has a lot of experience with climate litigation in the context of land use law. Have Australian courts engaged with human rights claims in the land use law context? And then second, we also have one from Anna Raineri, I hope. In the experience of the Environmental Defender's Office, is national law the main legal source in the buildup of climate litigation? And does international law also provide some source of legal basis for these cases? If you would like to weigh in on that.
Thanks, Linya. Great questions. So Steve's question is about whether Australian courts have engaged with human rights claims in the land use law context. I assume that he's talking more about mainstream planning law, not in an explicit sense, because in Australia we have no Human Rights Act at the federal level. At the state and territory level, so the subnational level, we only have human rights legislation in Queensland, in the Australian Capital Territory, and in Victoria. There have been, I practice in New South Wales, but I also practice in other jurisdictions within Australia. And the Australian courts have not really engaged with human rights claims in the land use law context. The Australian courts have talked obliquely about things related to human rights, for example, impacts on health, both physical and mental, of the community, impacts on life, impacts on property, but they haven't couched that jurisprudence in the context of human rights. It's not very sophisticated, unfortunately. Hopefully that'll change. Anna's question, is national law the main legal source in the buildup of climate litigation in Australia? No, it's mainly state and territory based at the moment, particularly in New South Wales. New South Wales is a really good jurisdiction to practice in, and that's where Sydney is, because our Environment Court is a superior court of record, which means that it's on the same level as the Supreme Court of New South Wales. That means that decisions of the Land and Environment Court in New South Wales are usually binding, particularly if they're in the judicial review jurisdiction. So the decisions of Chief Judge Preston, many of you will have heard of the Chief Judge, and other judges of the LEC have been very influential, not only at the state and territory level, but also at the national level and internationally. Our federal legislation in Australia, in terms of the environment, actually doesn't mention climate. And some of you who are familiar with our political environment over the last 10 years, we have had, I think, 3 or 4 different prime ministers who have now lost their jobs because of the climate wars in Australia, because we are a resource-dependent country. We are a chief exporter of coal and other fossil fuels. So there is a very large portion of our economy that tries to fight for the rights of those particular companies. At the same time, however, Australia is one of the countries that will be most affected by climate change because of where we're located geographically in the world. We have a lot of desert as well, and things like the Great Barrier Reef, which will be very much affected. So it's a very difficult area to practice in federally. So national law is not really the main source of law in terms of climate litigation. And the risk nationally is that there are cases that we bring, EDO and other groups. We do try to run cases based on the federal law, but it is harder. It is harder than at the state and territory level. And that's why, one of the reasons why, unfortunately, the Sharma decision was overturned, because the federal legislation is more difficult in terms of climate, because it doesn't mention climate change, which leads to the next sub-question of Anna's, which is, does international law also provide some sort of legal basis? Well, as some of you will know, Australia, being a common law country, is a dualist system, not a monist system. So for international law to be legally binding in Australia, it needs to be transformed into domestic legislation, unlike, for example, in Switzerland, where if the government signs a treaty, it automatically becomes law. Sadly, that's not the case in Australia. So even though international law is persuasive in Australia, it is not binding. Thanks, Linya.
Thank you so much for that detailed answer, Matt, and for the very interesting perspectives on subnational legislation and litigation. Judge Malik, you also would like to weigh in here?
Yes. I just wanted to add that on the question about land use complaints and climate change. So we have a lot of litigation based on land use claims and climate change. So the cement factory, the DG Khan cement case, that actually was a land use complaint being a negative area. The issue was whether or not the cement factory could be made over there. Cases pertaining to establishing housing societies in an area which involved cutting down the forest, cases involving setting up industry in an agricultural area, So I've heard cases where the complainant has come to say that there are poultry farms being set up in a close vicinity to a residential area, and that they don't have any proper mechanism to get rid of the dead birds or even to clean the area, and all the water that they're using is going back into the soil. And so you have a lot of discussion again from the environmental point of view of whether that, that's not permissible. And generally, the courts tend to lean in favor of the environment and don't allow land use which in any manner will damage the environment, which even involve, like I said, protecting the ecosystem. So just on a point of note that we do have cases pertaining to land use.
That's really interesting. Thank you so much for that, Judge Malik. We also have a question from Maria Antonia for Lorena, who has turned off her camera, but I hope is still with us. There, she's back. So Maria Antonia asks, how does the recognition of the right to a healthy environment by the Inter-American Court of Human Rights influence climate litigation at the domestic level across jurisdictions in Latin America? If you would like to weigh in there.
You mean at the Inter-American system?
Exactly.
How I said at the beginning, like the right to live in a healthy environment is being recognized in many constitutions in Latin America, and it have an impact because the people use and brought their claims under that. Under the Inter-American system, I can see it has an impact on the judiciary, because judges know and the state has responsibility and follow the agreement of the Inter-American system. So I think it can be a good step in order to making judges and litigants to recognize the right even when it's not implemented in a legal disposition. So I think it's a good recognition, and also the recognition that made the United Nations also for sure will have like some kind of dissuasive effect on the judiciary.
Great, thank you, Lorena. I think that's an interesting point to also touch on with all of the panelists. So Matt, in your presentation, you mentioned that Australian climate, I don't want to say activists, but people working in the climate area are sort of advocating for the inclusion of the right to a healthy environment at the domestic level. What do you think that would mean for domestic climate litigation in Australia?
I think it'll be quite exciting, Linya, because it will potentially enable some hooks on which we can latch certain new cases. What we need, I think, is human rights legislation in some of the jurisdictions that are more resource dependent, because in Australia we have some states and territories which are very much fossil fuel dependent still, but other subnational jurisdictions which don't really use much fossil fuel projects. For example, Tasmania, which is a beautiful island off the coast of Australia, doesn't really have much fossil fuel development, whereas Western Australia and Queensland, being two large exporters of fossil fuels, it'll be quite interesting to see how the legislation goes there. There's no human rights legislation in Western Australia, but there is in Queensland now. So I think from a law reform perspective, it's great to have that particular statute there, that then feeds into potentials for climate litigation.
Great, thank you so much for that. Ricardo, you might also want to weigh in here, because of course the litigation that we're seeing before the international treaty bodies are related specifically to the treaties that those bodies are tied to. But do you think that the recognition of the right to a healthy environment by the Human Rights Council last year could affect future climate litigation at the international treaty body level?
Thank you, Linnea. Well, you said that actually, meaning that this does not give another specific tool to litigate at the UN level at the moment, but of course it can foster, if you want, litigation, current cases, or even future cases. But at the moment, this type of litigation at the level of the UN Human Rights Treaty monitoring bodies is actually happening by greening, or if you want, climatizing general human rights, like the right to life, or as I said in the presentation, the right to culture. That is, in particular for indigenous group, another important entry point for litigation. But for sure, it can be, a way to foster litigation, generally speaking, litigation in the future.
Thank you, Ricardo. And what about in Pakistan, Judge Malik? Do you think that an international or a sort of domestically implemented international right to a healthy environment could be useful?
I think it'll be useful to the extent that it'll add value, and there'll be more. We'd rely on an international document now, but since we have been already using we've already read in the right to a healthy environment in the fundamental right to life. So domestically, that's really how we have been navigating all environment cases and now climate change cases. So that's the hook that judges find, that they can sort of latch on to, and then sort of craft their way through the problem and see what solution they can get.
That's so interesting. Thank you so much for that. We're now going to turn to some of Italy's litigation because Anna Raineri has a question there. I also have one of my own, but I'll keep that for later. But she asks, in terms of Italy's litigation, to what extent is there specific consideration for cases brought by climate-induced migrants, if at all? Ricardo, do you have an answer there?
Thank you very much for the question. Well, today I mainly dealt with international human rights bodies, but of course I'm happy to answer also questions about Italy. I hope that this shows also that we are in the network quite dynamic and interchangeable, of course, under the guidance of Maria Antonia. And it is actually a very pertinent and good question, and that allows me actually to connect, if you want, the Italian framework with the international one, because last year I think we had an important ruling from the Supreme Court of Italy, the Court of Cassation, on requests for international protection, in which the court recognized that international protection can actually should be granted also in situation in which you don't have an armed conflict scenario in the country of origin, but a serious, important environmental degradation or impacts by climate change that, of course, affect the life of the applicant in the country of origin. And actually, this ruling was based on the Teitiota decision, that, as you may know, the Teitiota decision by the Human Rights Committee, that is a decision of rejection, but still the Supreme Court of Cassation of Italy based its ruling on that decision. So I think it is something quite relevant and important. So thank you very much for the question.
Wonderful. Thank you so much for that. We also have a question from Kianru Ma, who asks, what role can or should perhaps judges play in rights-based climate change litigation? What is the premise of a judge's discretion to apply human rights law? Judge Malik, you seem particularly well suited to answer that question, but I'll also open it to the other panelists after you go.
So again, I sit in a constitutional court. The discretion is fairly wide. Once you've crossed the standing issue and you've looked at the matter and you feel that this has, the makings of a climate change injury, or there are issues here that need to be addressed, the court can literally sort of craft its way through any kind of relief that, so long as it remains within the four corners of the Constitution, is pretty wide discretion. And that's, again, how the narrative has been built in this jurisprudence with respect to climate change and even environment cases. I think what's important to note here that every case that comes to the court may not necessarily link itself to climate change, or may not necessarily even, the complainant may not even know that this is a climate change issue. Once the matter is before the court looks at it from its various different angles and then can decide literally in any direction how it wants to proceed. So in a case that I was hearing pertaining to the culling of dogs, it was an appeal that had come from the decision of a single judge who dismissed the case, saying that this was a policy issue and culling of dogs was not something that the court needed to look at. In my appellate jurisdiction, we were two judges, and when we looked at the matter, we thought that it actually does need to be looked at, because our concern was the disposal of the carcasses of the dogs that were being killed. And we also wanted to know why such a large number of dogs were being culled and what was the reasoning behind it, what were the health issues, what were the concerns. And so while we entered into this area, we discovered that actually it was a misguided area. Nobody really knew what they were doing, and a large number of dogs were being killed, and there was no method of disposing of the carcass. So the court directed the government to think of a policy. It appointed an amicus and said that, come and give us solutions from around the world. And in fact, the case got so much attention that I had young children writing in and giving me solutions of how to prevent the culling of dogs. The end result was, with a lot of discussion on the impact of disposal of carcasses and even the negative impact on the environment so far as just killing the dogs is concerned. But ultimately, the government of Punjab introduced a policy where it prohibited culling, and there was a whole mechanism of dealing with these wild dogs and based on international practices. So, I mean, this is a way in which the court exercise discretion, and you can see the difference in the approach. The single judge didn't think it was a matter that required attention, but I thought that it did require attention, because I wanted to know what they were doing with the carcasses. So discretion in constitutional jurisdiction is fairly wide, and it's really about the perspective that the judge has on how they want to look at the case. Like I said, it doesn't necessarily have to have a climate change narrative to it, but you can actually bring the climate change narrative or the environment narrative into the case. So I hope that answers the question.
I think it answers it very, very well. Thank you so much for that. And for a very interesting story as well. Do any of the other panelists want to weigh in on this question? Perhaps the role that you think that judges should have? Lorena.
I'm sorry. I wanted to participate on this discussion because from my perspective of Latin American jurisdiction and how I say the money system in those jurisdictions there is not a discretion for judges in order to solve under human rights law. It is mandatory, if the plaintiff put this claim on their petition and is under the proper action, judges must solve considering human rights arguments. It's like it does not depend of which is the belief of the judge of what is human right or what is not human right. The reality is not all the judges do that. There are a lot of reasons because of that, but I don't think there are a lot of discretion. Most of the requirement of the formal procedure. So this is my opinion. Thank you.
Thank you for that, Lorena. Ricardo or Matt, do either of you want to weigh in, or should we perhaps move on to a different question?
It depends on the judge and depends on the court. Judges can be quite idiosyncratic. But judges know everything about what's going on in terms of the trends in domestic and international law. And the higher up you go in the hierarchy, the more they may be willing to exercise their discretion in a common law country like Australia to be persuaded by international trends. For example, at the High Court in Australia, which is our Supreme Court, several judges in the past, including Justice Michael Kirby, former judge of the High Court, placed an emphasis on interpreting statutes consistently with international obligations, those obligations being persuasive, though not binding. In the Land and Environment Court in New South Wales, judges like Chief Judge Preston have referred to the Paris Agreement and to international law. So it just depends on the judge, and we're very lucky to have Justice Malik here with us today. So thank you for joining us as well.
Thank you so much for that, Matt. And I can only reiterate that. Thank you for Judge Malik as well. I think we'll shift a little bit away from the sort of purely judicial perspective and shift back to the international human rights treaty bodies. And I'd like to ask Ricardo a question here. So you mentioned that the litigation that's happening, if we can call it litigation, that's happening before the treaty bodies is a small fraction of the litigation that we see happening in general, but also with respect to human rights specifically. But you claim that they are a very important source of litigation. Can you maybe unpack that a little bit? Why are those cases so important?
Sure, thank you very much. Thank you very much. Well, I think that they are yet another tool to plug the accountability and enforcement gap that we have in climate change law. Of course, as you also mentioned, I mean, they are far from being the perfect tool, but we do not have yet a perfect tool, so they can act as a gap filler. They have many limitations also in terms of the remedies they can grant, for instance, but still, I think that their decisions might have a strong impact also beyond the specific legal outcome of the case. We might take, for instance, the case of the Inuit petition that was groundbreaking before the Inter-American Commission in 2005, even if it was dismissed immediately. I think that we can argue that it had an impact on how climate litigation and human rights-based climate litigation developed in the following years. And then also I just made another example that was the impact of the Tetiota decision, for instance, in domestic litigation and in the domestic system in Italy. So even again, a decision of rejection was actually, I mean, the Supreme Court, the Court of Cassation in Italy, based its ruling on that decision, that is the Tetiota decision. So I think that also is an important example of the impact that these complaints can have. So more generally speaking, they can provide an interpretative guidance also to domestic courts that is very important, I think. Thank you.
Thanks so much for that, Ricardo. I'd also like to follow up on this with Matt. So of course we have the Torres Strait Islanders case pending before the Human Rights Committee. And I'm wondering sort of how you see that playing out at the national level. What impact could a decision from the Human Rights Committee in that case have domestically?
Super important, I think, Linya, because there is a federal court case which is based on tort, I believe, a duty of care case involving the Torres Strait Islanders. And I think when we look at concepts like the duty of care, there is some space, I think, for human rights considerations to be incorporated within that. maybe not necessarily using all of the language and the architecture of international law, but at least some of the import of that into the tortious duty. Because, for example, in the initial decision in Sharma, the judge did refer to the history of the development of the tort of negligence and placed that alongside the concerns of the children, of the Australian children, and their right to intergenerational equity, their right to biological diversity, and the precautionary principle, as well as the polluter pays principle. So the principles of ESD. The principles of ESD come from the Rio Declaration, come from a lot of international agreements, international environmental law. So yes, I think that the Torres Strait Human Rights Committee complaint, case, quasi-litigation, what have you, I think will be quite important for not only the federal court case, but also other cases.
Thank you so much for that. I think that also raises an important and interesting point. So many of you have touched on the notion of intergenerational equity throughout this conversation. And so I would like to ask a little bit about that. So how is intergenerational equity as a principle being used in the litigation that you see in your respective jurisdictions? Is that something sort of judges are including on their own independently? Is it something that litigants are basing their arguments on? How do you see that?
So in Pakistan, intergenerational equity has been something relied upon from the cases pertaining to the environment. There are principles that the courts have invoked for preserving the environment, whether it's green belts, whether it's the forest, whether it's the canal road and the trees on the canal road. And the basic idea has been that the environment is something that we need to look at not only to protect it today, but for the purposes of the future. As time went on and you bring these terms into the judicial narrative and start invoking these international principles, then you see that public interest litigation, the litigant starts using these terminologies. So now for climate change, this becomes a specific argument, like the Coalition of Women who came to court, they specifically used this argument, and this was the ground for coming to the court. But the court has, while protecting the environment in various different cases, definitely relied upon this by for the purposes of preserving the natural resources, for preserving the ecosystem, for basically preserving the environment for future generations. So this is a concept that is used in cases that judges do rely on, much like other principles like the precautionary principle. And I think the idea, again, like I said, is that once you open the door and you've decided that this is going to be a human right issue, there is causation there, and you're going to then, look for the means of kind of like putting things together and looking for ways and means to justify your interference and to justify the preservation or the measures, the adaptative measures that you want taken. So even in the ongoing case with respect to the deforestation of in Sindh, that is a massive area. And this is a very big concern. This is one of the arguments raised, that if the government allows deforestation to continue and keeps letting out that land and allotting it for different projects, there will be nothing left for future generations. And then I think the importance of the climate change litigation is that you have more narrative coming into the judgments of why this is important, of how this will affect future generations. So you have, this creates awareness. I think that's one of the things that it does. It also makes judges more conscious of the fact that they have these principles available to them as tools to use to justify interference. So I think at this stage, because the cases are still at the initial stages, and it's really more about pushing the government to do what it's required to do, this helps a great deal. And that's the context in which it is used. So it's used to kind of justify interference in the cases.
Thank you so much, Judge Malik. That's really an interesting perspective.
I mean, I can add that in one of the cases, the judge had written that we owe it to ourselves and future generations that we maintain a beautiful, rich, and healthy environment. So like I said, you know, it's a judge's perspective, and the more the judge feels the environment and the more the judge cares for the environment, the more the judge is going to sort of write things like this. And I think this is important because once you you create precedent where a system that relies on precedent, then that narrative continues, and it gives other judges the ability to use these kind of findings.
Thank you so much. That ties nicely back into sort of the role of the individual judge as well that we were talking about earlier.
That's right.
Do any of the other panelists want to weigh in on the intergenerational equity topic or question? Is that playing a role? Matt?
Yeah, we're lucky in Australia that the International Environmental Law principle of ESD has been incorporated into domestic statutes at both federal and state and territory level. So that's a win for our litigants and for the environment. So there is already a lot of litigation about intergenerational equity and the precautionary principle and polluter pays and biological diversity in Australia, with an emphasis, I think, on the precautionary principle and intergenerational equity, less case law on biological diversity and polluter pays. That's a space to watch for sure. It's interesting, I did a course a couple of years ago at Lewis and Clark Law School on US environmental law. And in the United States, the principle of ESD is not incorporated into much domestic legislation. It is here and there, but it's not done so in a comprehensive way. So I think the US climate litigation that I've looked at, although it has referred to several principles of ESD, it's done so through means of persuasion rather than being bound by them via domestic legislation. I think by having it as binding as it is in Australia and in other countries, of course, and it's really heartening, Justice Malik, to hear that it's being used in Pakistan. That's fantastic. I think it just is another tool that climate litigants can use to persuade judges to decide in their favor.
Great, thank you so much for that, Matt. Ricardo, if you would like to unmute yourself as well.
Yes, thank you, Linnea. Well, at the international level, we have at least two important complaints that are brought by children or young people. So the Duarte Agostinho complaint before the European Court of Human Rights and the Saki complaint before the Committee on the Rights of the Child, that I think will be discussed more in depth in the following panel. So they somehow claim to represent, if you want, future generation. And then more, I mean, legally speaking, they also use the best interest of the child under the Convention on the Rights of the Child, or the right not to be discriminated against under the European Convention of Human Rights, as you know, arguing that children or young people are actually suffering the strongest effect impacts by climate change. And I think this is a more controversial point. I think that somehow the principle of intergenerational equity or the rights of future generation clash with the victim status requirements, meaning that the applicants has actually to prove that he suffered already personally, he or she was personally affected by climate impacts, or he or she is at immediate risk of this impact. So this is a controversial point, I think, but it has to be highlighted that it is not always easy at the international level to for the rights of future generations or intergenerational equity to play a role. Coming back to Italy, switching and going to Italy, it is very important that we recently have a constitutional reform by which we now have environmental protection included in the fundamental principles of our written constitution. And this is also done in the interest of future generations. So this is actually the wording. I think this is, important, and it might be another way to foster climate litigation in Italy. Thank you.
Thank you so much for that, Ricardo. We also have a comment from Professor Jagede in the chat, who is saying that in South Africa, intergenerational equity is entrenched in several domestic legislation on the environment, but much will depend on arguments made by lawyers, and practicing lawyers need to be aware of the potential of this and like principles and use them to found claims. So that's also an interesting perspective from South Africa. So we also have a question that has received a little bit of an answer, but I've seen it come up a few times. So I'll ask it from Peter Splinter, who writes that in Switzerland, there have been some lower court cases where necessity attributable to the prevention of climate change has been invoked unsuccessfully as a defense to criminal charges related to protests against climate change. To my best knowledge, human rights were not invoked. Are there examples of litigation elsewhere where human rights have been invoked as a defense against charges related to protests against climate change? Is that something that has happened in any of your jurisdictions that you're aware of? So litigation, criminal litigation against climate protesters.
No, I would say no, not over here. There are protests and there are awareness marches, but because we recognize the freedom of movement, and any such protests really haven't been disruptive. So no, I don't think any such litigation has come to court. I mean, I could go off on a tangent and mention how it has in cases pertaining to gender issues, but certainly not climate. Certainly not climate.
Okay, thank you so much for that, Judge Malik. I'm also not seeing much of a reaction from the other panelists. Matt is unmuting himself, so maybe.
I think there's potential. There's potential, particularly if the right to a healthy environment is incorporated into some of the existing human rights statutes in various jurisdictions in Australia. There are a lot of protests, for example, in Queensland being a very large exporter of coal, one of the world's largest. So I think if there were a right to a healthy environment incorporated into the Queensland Human Rights Act, certainly, why not raise it? I mean, it would be raised in the first instance at the lowest court level, the magistrates court, the local court. The question then is, would the magistrate be persuaded by that? The lower courts, and of course, no disrespect to the lower courts, they handle the vast bulk of cases, but generally the magistrates are usually less persuaded by novel arguments. So it would need to be appealed to a high court. High courts are usually more able to exercise discretion. And that's where I think the strategy as a litigation lawyer comes in, when to raise a novel claim, before whom, and what is the substance of the claim.
Thank you so much for that, Matt. We also have a comment from Natalia Kobilarz, who notes that this has happened in France in a series of cases of people who entered town halls to take down portraits of President Macron. So Peter, that might be something for you to look into. We're starting to run short on time, but we do have a question from Anna Raineri, who asks, with the new Chilean constitution in the making, is there hope for more effective application of the right to a safe environment in courts at different levels? Lorena, do you have anything to offer there?
Yes, because now it's being discussed, the new constitution, and as I say at the beginning, like the right to live in a healthy environment, it was already in the constitution of 1980, but I think it will be a very effective if beside that recognition, the constitution can contain like other aspects like granting access to justice, access to participation, independence of the environmental bodies. So it's not just the recognition, we also need some legal implementation, because if not, the people just have the right, but they don't have the way or make that right effective. So this is my opinion. Thank you.
Thank you so much for that, Lorena. We have the final question, which comes from Maria Antonia, who asks about Indigenous people's rights and litigation. Of course, we've touched a little bit on the Torres Strait Islanders case, both domestically and before the Human Rights Committee. But are there any interesting sort of Indigenous people's rights claims that you see in your jurisdictions, or ways that could be pursued domestically, regionally, or internationally? Any perspectives on climate litigation there that you have to offer? Lorena?
Yes. So like historically in Chile, like the indigenous people have been the one that have been protecting the environment since many years. So now what I have seen, like they continue doing that. And in the past they were very criminalized because of that. And now that we have the lithium extraction in the Atacama Desert, so are them who are like arguing and trying to protect the cultural heritage. So I think this situation is going to continue developing in the future, and as we don't have like a real policy about the just transition process over the extraction of minerals. So that's what can I say about what is going on now in Chile. Mm-hmm.
Thank you so much for that, Lorena. I think that just transition question is one that comes up a lot in connection with Indigenous people's rights as well, and I'm sure litigation that we'll see coming in the future. On that note, is there anybody in the panel that is familiar with just transition litigation happening in their jurisdictions that they're covering? So litigation, sort of anti-climate litigation on the basis of human rights. Is that happening at all? Judge Malik? You have unmuted yourself, at least.
So I would say no direct case on just transition. No case that has specifically raised this issue. But indirectly, yes, because when you're looking at complaints with respect to industry, with respect to development projects, you're looking obviously at a large number of jobs that are being created, and you're looking at the argument from the other side, which is talking about the right to their profession, the right to trade. So there are cases in which these arguments have been made, but no specific reference to just transition, because I would say that we don't really have a model from where we are. We could say that we're transiting to a better, more sustainable model. The cases are really random, and because it's public interest litigation, it's really based on the public's perception of what they think is going wrong. But when cases, I think, again, I have said this several times, that when complaints come to the courts start interfering and they kind of write in the narrative, that helps the public also. That's a way of educating the public. And the more you educate the public through judgments, the more aware people become of the various different tools they can use to invoke the jurisdiction of the court. So I would say in times to come, we will be seeing this kind of litigation, but not at the moment.
Perfect. Thank you so much, Judge Malik. Matt, final word, I think.
I agree with the judge that this is an area that will grow. There is ample legislation in Australia, in New Zealand, in Canada, in the United States, dealing with Indigenous peoples that could be used as a ground for climate litigation, even if it's not the main ground, potentially a supplementary or subsidiary ground. There's also, I think, two things about human rights discourse which perhaps can be unpacked. Firstly, its anthropocentric nature. So in opposition, or perhaps in tandem with human rights, are rights of nature. And there is legislation now in New Zealand regarding the rights of rivers. There's legislation in Melbourne and Victoria in Australia dealing with the rights of the Yarra River. So potentially there is an opportunity to move away from an anthropocentric approach to a more ecocentric approach. The second element of the discourse, I think, is individual versus collective. So Indigenous peoples, many of them, have a more collective approach to the law, to the environment, whereas in a lot of the Western world, it's a very much individual focus, including the discourse on human rights. So I think there is potential to perhaps incorporate some change of language about the way we talk about rights, not only rights held by individuals, but also rights held by groups, rights held by different cultures, etc.
Thank you so much, Matt. Okay, Ricardo, a very quick final word to you, and then we will start wrapping up.
Okay, so very quick about the role of indigenous people. I think that it's important to stress that they are really an important actor also at the international level. As I said, the right to culture as intended of the right to indigenous people, I mean, for indigenous people to enjoy the benefits of their own culture is an important entry point for litigation at the international level. We know the Inuit petition, the Athabascan people's petition that, to the best of my knowledge, is still pending. I don't know if you have different information, it's still pending before the Inter-American Commission since 2013, or the more recent that has already been mentioned, complaint Torres Strait Islanders against Australia. About just transition, we do not have proper just transition complaints at the international level yet, even if we have similar, let's say, complaints of some years ago. But I think it's a very hot topic, important issue that will develop in the future. In Italy, we have a very interesting, but also very recent legal initiative on just transition that it's still quite confidential, but overall it involves, let's say, the role of a big company in the automotive sector and the supply of some of those materials that are very important to batteries for electric cars. But it's still, this is some in the making.
Thank you so much for that,
Thank
Ricardo.
you.
And on that, I think it is time to close panel 2 on climate litigation and human rights. So I would just like to thank all of you panelists and participants so much for your excellent input, for all of the excellent questions, and for taking your time to be here with us today. And on that note, I'm going to hand over to Maria Antonia to sort of close us out.
Thank you so much, Linnea. This was a wonderful, wonderful panel, and thank you for moderating. It was excellent. So we'll have a little bit of a break now, half an hour. We'll be back in half an hour with the next panel. So thank you so much to all the panelists this morning, and we will continue shortly. We'll see you soon. All right, welcome back, everyone, for our afternoon panels. We're starting with panel 3 on youth-led climate litigation. So I'd like to introduce you to our moderator, Juliana Case, a PhD candidate at the University of Geneva, who will introduce the panelists and moderate the session.
Thank you, Maria Antonia, and good afternoon to everybody. Welcome back to this session. I'm going, as Maria mentioned, I'm going to moderate the third panel for today, which is focused on the youth-led climate change litigation. And we are going to try to bring the voice of the young generation in this panel on one side, and on the other side, the voice of the international mechanism that protect human rights, such as Committee on the Right of the Child. Before presenting the panelists, I would kindly remind that the session is recording, and each of the panelists has just five minutes to present their case, and this session is focused on the question and answer due to the short time of this panel. So I have the pleasure to present today to this panel Madame Mikino Otani. She is a member of the Committee on the Right of the Child. Ms. Iris Dokuesto Ederadi Mapandei, they are both plaintiffs in the Sashi and All versus Argentina case. Laura Jimenez, she is plaintiff in the Future Generation versus Ministry of Environment and the other Colombian case. And as you may be aware, in October 2021, the Committee on the Right of Child has published a historic ruling on the complaint that was brought by 5 member states, such as Argentina, Brazil, France, Germany, and Turkey. Ms. Otani, if you can kindly provide us some tips on the role of the Committee on the Right of the Child in this case, and how the general comment can help member states to provide their role in the climate change and protection for the children's rights. Thank you.
Juliana, And thank you very much for having me with the young litigants of the climate litigation cases on this panel. It's such a pleasure and a precious opportunity for me to directly hear from and learn from the young people who initiated the climate litigation. I'd like to start by saying that the role of the Committee on the Rights of the Child is important. As a monitoring body of the UN Convention on the Rights of the Child, the committee has various functions. These include country reviews, general comment, and individual communications. Individual communications are very powerful, as this procedure may have multiple impacts on enhancing child rights. It can provide, of course, remedies to child victims at the international level by finding violation of state obligations. It also gives opportunities for the committee to analyze and develop its jurisprudence through specific cases on certain issues, such as global climate change. Some cases can have even broader and significant impacts, stimulating academic debates, raising awareness of the issues, and leading to more use of individual communication procedures. The climate change case filed against the 5 committees, Saki et al. Versus Argentina and other 4 countries, is exactly a landmark case of such nature. 16 children and young applicants of the case made tremendous contributions, as the committee can act only in response to the actual complaints brought before it. The committee's decision is alluding on the historic case, I would say a historic case rather than historic ruling. Because of the child and young applicants' courage and activism, the committee could address and make a pronouncement on the state's cross-border responsibilities for harmful impact of climate change on children's rights, such as right to life, right to health, right to culture, and right of the best interests of the child. This climate change case presented many relevant issues. Under the individual communication procedures, applicants have to first try to seek remedies in the national courts, but this rule doesn't apply if domestic remedies are unreasonably prolonged or unlikely to bring effective relief. So there are many questions. Does the urgency of the climate crisis to children have legal implication on the assessment whether national court procedures are unreasonably prolonged? What kind of reparations are required to be qualified as effective relief for child victims in climate change cases? Are courts required to issue orders to governments to stop or make specific actions? Are there legal obligations of states to cooperate with other states in the global climate change? If so, what are the scopes and contents of such obligations? What are the legal obligations of states toward children affected outside their borders? Shall states provide potentially affected children abroad with access to information, participation in decision-making, impact assessment for prevention, and also access to justice for remedies? Whether and how shall the international environmental law principles be incorporated in the state's obligations under the Convention on the Rights of the Child? These are just a few questions to mention that I have. General Comment 26 on children's rights and the environment with a special focus on climate change that the committee is currently working is a real opportunity where the committee can clarify and provide guidance to states on many such legal issues, both substantive and procedural. To make the general comment meaningful and impactful, inputs from children and young people drawn from their experiences of litigations are very valuable. In this regard, I'd like to emphasize that General Comment 26 can also address procedural challenges children and young people are faced in climate litigations. So how the General Comment 26 can help member states to improve their roles on climate change and the protection of child rights? It depends on what the committee states on which basis, legally, evidence, good practices, expert inputs, consultation with children, young people, and stakeholders, submission from states. It also depends on how widely the General Comment will be known, understood, and used by decision makers, policy makers, judges, lawyers, children, and youth. General comments are expected to have influence on state actions being implemented by states and integrated in the committee's recommendation to states, but also used in litigation at the national courts, regional courts, and also in the individual complaints to the Committee on the Rights of the Child, but also to other treaty bodies. So there is a potential use of the general comments even by the other treaty bodies, because there are many states who ratified the optional protocol to ICCPR, for example. So I'll stop here. Thank you very much.
Thank you, Ms. Dotoni. And as you mentioned, this was the historical case because it was submitted by a number of complainers. And we have the pleasure to have today among us Iris and Radima, both the plaintiffs on this case. And they can, I will kindly ask them, what was their expectation for this case, and why they decide to bring this case in front of the Committee on the Right of the Child.
Thank you for having a date. Thank you for having me. Sorry. The reason I decided to bring this case in front of the Committee for the Rights of the Child was because I think frustration, and I think it can be felt by a lot of other youth like me. I think because we are young and because we don't have much experience, adults and people that are more experienced tend to overlook how we feel and what the ideas that we might have. And that's a mistake because the global crisis, the climate crisis is a global crisis, but it's also an intergenerational one. So it's a problem that affects everyone, and we need as many ideas as possible, and we need as many opinions and points of views. So for me, at least, it was mostly frustration and not being able to protect my future, but also not being able to protect other people's future. And I thought it was the best way to bring awareness and knowledge and understanding from other people to the global crisis that I felt that a lot of people around me weren't really paying attention to. And for me, it was kind of a glaring problem. So I think Radima can also talk about it.
Yes, Radima, if you can tell us your experience on this case and what are some challenges that you faced during the submission of this case?
I mean, what I can say is that, I mean, of course, it was, again, for me as well, it was the frustration, but it was kind of like, more of a disappointment for me rather than, the frustration was there, but, I mean, I filed a petition in my country and it was dismissed. So, I mean, there was this disappointment that, nothing was I was not able to do anything. And when I got this opportunity to be part of the, case, it just felt like a ray of hope for me personally. And yeah, it's just that, I feel that all of us, like all the petitioners, in some way or the other, did some of the things, to make things better, to take actions in our country. But it was all just, toned down, whether it was, the government didn't listen, or, the people didn't took us seriously, or we were, underestimated because we were kids. So of course, if we all got this, when we all got the chance to be a part of the case, which would bring, that big of a difference where 5 countries, if the result would have been positive, 5 countries would have been made to reduce their carbon emissions. And for me, it was like, a really big deal. So I can say that sort of is the reason why I became part of the petition. And to be honest, I mean, what like problems that I faced, I mean, personally, when it comes to like all the works and stuff, it was pretty smooth because of our lawyers, I can say, in a way. I mean, they helped us a lot, and they explained us each and everything, and they were always there for us. So I can say when it comes to the part of the case, personally, it was really nice. But when it comes to, the challenges that I faced personally was, I mean, it was quite a lot because, I mean, people were not happy with what I did, and I mean that I was part of the case. So I mean, my dad has been working with an organization for the last 20 years, and they didn't renew his contract just because I was an activist. And people were like, they were filing for FIRs against me and my parents, saying that they are destroying the wildlife, the environment, even though me and my parents have been working to conserve the biodiversity for more than 10 years. So it's just that people doesn't like what I do, and people doesn't like that I was a part of the case, and I'm raising my voice for myself. So yeah, I mean, for me personally, things were not that great, but when it comes to as a group, when it comes to working like within all these things, I guess it was pretty smooth with our lawyers.
Okay, thank you. And maybe I'm coming back again to all of you that you have faced the kind of challenges and all this kind of requests. But I'm going to pass the floor to Laura, and I'm going to ask her, because she represents the case Future Generation versus Ministry of Environment and the other Colombian case. And I want to ask her how this case has influenced climate change in our country, and what was the case bring, and what was the result of this case.
Hi everyone. I was part of this case that Juliana is talking about. We are 25 girls, boys, and youths who demanded the government, the Colombian government, and we demand that they have to protect the Amazon jungle from deforestation, because the rates of deforestation have been increasing since 2016. In the moment we filed the lawsuit, we were between 7 and 26 years old. It was 4 years ago. Right now we are almost 10 or between 10 and 30 years old. And we were really frustrated, like Yuri said the last time she talked, because we were young people, we were girls, we were boys, and we didn't know what to do about climate change. And we didn't have any, how to say it, like we couldn't make decisions about what government could do in front of this problem. So we talked with this organization, the Justicia, and we said, like, we want to do something, but we don't know what can we do. And they told us, like, okay, let's do this lawsuit, and maybe we have some success. In first instance, in front of the Superior Tribunal of Bogota, they dismissed our petition. But in second instance, in front of the superior, excuse me for my English, I am trying to translate while I speak. The Supreme Court ruled in favor of us in 2018. They say that we have right to a healthy environment, and like future generations, our rights must be respected, because, okay, right now in 2018, there is no problem, but in 2015, what is going to happen? And if we keep this deforestation rate, what is going to happen, for example, with the water we use in the cities that comes from the paramos, and the paramos take this water from the Amazon jungle? It's like a ecosystem connection. And if we broke this ecosystem connection, it's going to be a problem for us, like future generations. Right now, we are in the implementation of the lawsuit. We were successful, but it's been difficult because there are structural problems. The government says one thing, and then they do other things. For example, they say, like, oh yes, we're protecting Amazon jungle, and then they approve fracking, or they didn't do anything in facing this problem with all the guys who are deforesting. So it's been a difficult implementation in this matter. And on the personal level is hard for some of the plaintiffs. For example, for me, it's not a problem because I live in Medellin, a city that is far from the Amazon jungle. But for example, other guys who live in Florencia or Leticia have many problems because people is angry. They say like, you're affecting our lives. You want that the deforestation stop, but deforestation is the only way we can live here. So that's what is been happening.
Okay, thank you, Laura, for your presentation. And I would like to open the floor for question and answer from the panelists and from the participants. So we have one question. Could the panelists speak more generally about their experience collaborating with the lawyers and public interest organization who helped them bring forth of this case? So the question is for each of you. Would like to start first? Maybe Iris or Radima, Laura?
I mean, I guess when it comes to like working with our lawyers and working with other organizations too, who helped us throughout our case, I mean, in general, I mean, I don't know how to explain this, but I mean, how things happened for us was like, you know, whenever the decision would come from the, you know, say the committee, or if anything, you know, if there were any updates, we would get all the paperwork, and then we would have a meeting with our lawyers, and they would explain us what happened and, you know, how things would be and, you know, what it really meant. I mean, because I guess specifically, I don't know, I mean, I guess it was same with all of us, but it was a little difficult to understand the paperwork and, you know, the way it was written, and to, you know, get the basic thing of what the committee really wants to say or what's going on. So I can say, I mean, it was all those things. And then, I mean, with the organizations and everything, rather than like working with like within our case, we also got different opportunities to talk about our experiences or our experience with the case, or within, you know, this sort of whole sort of scenario that was going on. So yeah, I guess that was sort of it, and I hope that I answered your question.
Yeah,
Okay.
for me, I mean, I only worked on the Children's versus Climate Crisis and Isle versus Saatchi. So I think Radima has a little bit more experience with how many cases she brought forth. But for me, it was always really, how do you say, the lawyers were always really like looking after us because we're still children. So they still need to, you know, really like shield us and make sure that we understand everything. So it was always really focused on like our well-being and how we like saw the results, etc. So it's always really disappointing when a case is dismissed or, you know, canceled. But it's also really, it's always a really good experience, and also you get to learn new things and you get to meet people. And really, for me, the end goal, like optionally, really for me, was the case to not be dismissed and to continue forth. But really, for me, my main goal pretty much was bringing awareness to the climate crisis. And I think that we did that. I think it was really good in advertising how harmful it's going to be and how it will impact literally everyone on a social, economical, intergenerational, racial basis. So I think that we accomplished our goal, not 100%, but for me, at least, it was a big win.
Okay, thank you. And we have a question for Ms. Mikiko. It's from Maria Antonia. She asked if she could speak a little bit more about the draft general comments and how the process has been. Hopefully.
Yes, thank you very much for the question. But before answering the questions, I just want to echo what Iris and Radmir said, that I'm very happy to hear that Iris said you won and you achieved a goal, though I understand that you came to the committee after so much frustration and disappointment at the national court level, and then at the international level, you got another frustration. But I would like to echo that one of the purpose or the impacts of the case is to raise awareness. It's really had such an impact to raise the importance of this case, the issue of the climate change as a child rights crisis and child rights issues. And also your case has stimulated a lot of discussion among the scholars, legal scholars and legal analysis, which is very, very helpful because your arguments are very innovative, and you brought us very challenging questions which we need to answer. And the general comment is actually the opportunity for the committee to develop further those legal issues and other issues. So the draft general comment, the committee decided to take up this topic, environment, and also the particularly the climate change and children's rights. We decided to start the process in June last year, and it takes some time. And currently, we are going through the consultation process. The state parties are also given the opportunity to provide some inputs. So already the committee invited the states to provide some comments, and some 30 states have submitted the comments on our concept note, which is available on the committee's page. And we, together with the external partner, we have already conducted the online consultation, which is made mainly for adults. And currently the children's online consultation is going on. And also the thematic consultation are being held on some specific issue, such as the right to health, the environment, for example, or the intergenerational equity. Those questions need to be explored. So after the series of consultation, the committee will issue the draft comment for public consultation, and at that time, states can also provide specific comments on the draft. So I really hope that you, who are together with me on the panel now, can provide your inputs based on your real experiences for the litigation for the climate change. I hope I provided some information on the draft comment.
Thank you, Mikiko. And we have the last question, maybe because due to the time, it's very short and rough. First, congratulations for the presentation. I'd like to know how the children from the Global South would be completed from the draft of the general comment 26 once they are most affected throughout the world. It's from Mikiko. It's again for you.
Thank you very much. Yes, we are very much aware of the importance of this issue for the children in Global South. And so currently the consultation is going on online. However, the questions put on for the online consultations for the children can be also used for the consultation and workshop in person or online at the various level, regionally or at the national level or local level. So, and also we also keen to hear from the specific groups of the children, such as the indigenous the children or the girls or the children with disabilities. And but I would say that online consultation will not be so much equally accessible to the children in Global South because of the access to internet, online connection issues. So we are trying to make sure to receive the inputs from the children in Global South.
Thank you. And I will read the last one. Dear panelists, thank you for being here and sharing your experience with us and for your efforts in bringing litigation forward. It is so important. One thing that has struck me from litigation by a young person is an emphasis on issues of anxiety, concern for the future, and even mental health. Do you feel that these concerns can be expressed sufficiently through litigation? Maybe Iris, Laura, or Radima, who want to reply to this question, but please be briefly because we have just 3 minutes left.
Maybe I can say that we never expressed sufficiently this through litigation, and because there is never enough things to do about climate change. And for example, it is said like, oh, it is terrible that they dismissed our case, but for example, we had success and we also feel like we are doing nothing because we feel like our government doesn't do nothing. So it may, you say like, okay, we're trying to do something, but what we're doing doesn't help enough. So I think that you always feel like it's never enough.
Okay, thank you. Iris or Radima, who want to reply just briefly for this question?
I guess Laura covered everything.
Okay.
Yeah, I agree with Laura too. It's a lot of the times our actions and what we do and how we speak, etc. It can tend to feel a little bit useless just because of how slow every process is and how the systems work. We keep doing it because if I don't do it, I'm gonna have more anxiety. But yeah, it's very often it feels useless.
Okay, but despite your challenge that you have faced, you need, on my side, I think all of the person that are in participant today, they are going to support your courage and to bring out the voice of young generation. And daily to daily, we need to support much more the young generation, because when we speak for climate change is what is going to happen in the future. So this climate change belongs to you, the future generation. So maybe I'm going to stop and to close this panel for today. Thank you, each of you, for being here, for bringing the voice of young generation, and also the Miss Mikono. I'm going to thank her to bring the voice of the Committee on the Right of the Child and the amazing work that they are doing by providing general comments, recommendation for member state, and to push forward the process for climate change litigation and how to improve and to serve for the better world. I'm going to pass the floor now to Maria. And
Right. Thank you very much, Juliana, and thank you to our wonderful panelists. It was really valuable to hear from you. So we really appreciate you being here, and Mexico as well. Thank you very much. It's an incredible process that's going on now at Committee on the Rights of the Child. So we very much look forward to following that as well. So I echo Juliana on thank you for your participation, and thank you to the youth plaintiffs as well for your courage and for your continued efforts. So we will move on now to our fourth panel, which is on private climate litigation. So I would like to introduce you to our moderator, Andreas Hössli from the University of Zurich and the Swiss National Science Foundation. So he can introduce our panelists and move on from there.
Yeah, thank you so much, Maria Antonia, and thank you to all organizers behind the scene at the Sabin Center and UNEP. It's my great pleasure to moderate this panel on which is a bit different from the panels before, I believe. We will speak about private climate litigation. What do we mean by that? Well, it's quite different from what we typically think of when we think of litigation and the climate change litigation, which is usually against the state, right? State actors, countries. Whereas here we generally speak about litigation against private companies, which is quite different. And today we'll have the quite a bit of time, 1.5 hours to delve into that. And I have the great pleasure of moderating this panel with 5 experts from around the globe, which I will introduce individually before their 5-minute slot. As you can see from the program, we have great experts from Chile, Uganda, Italy, Indonesia, and Canada. So with no further ado, I think we can start. The way it will go, as I mentioned, is we have 5-minute speeches of our experts. And then after that, we'll have about an hour time for discussion. And I'm sure there will be many questions and comments from all the participants. Right, and finally, as a matter of housekeeping, I'll remind you that this session is being recorded. So let us go to our first panelist. The first panelist is Professor Michael Handke Domas. I hope I am saying that more or less correctly. He acted as a Chief Justice and Justice of the Third Environment Court in Chile. And today he is Associate Professor at the Law Faculty at the University of San Sebastián in Chile. The floor is yours, please.
Many thanks, Andreas. Well, good evening, everyone. Good morning to the people who are in behind the time. And well, thank you for this invitation. Well, we are, as Andreas mentioned, we are going to discuss about private litigation. Coming from Latin America, I have to start by stating that in our continent, there are many legal developments occurring in terms of private litigation. Although we have big ones, they are not that common, okay? And usually the litigation in Latin America is that the most salient feature on environmental law is the ecocentric gist of constitutions. So for us, it's very important the structure of the law, particularly constitutions, as they are the base for litigation and base for the whole legal system. And this trend in Latin America has been spearheaded by Ecuador, when in 2008 they changed their constitution, followed by Bolivia in 2009. And nowadays we are experiencing the same discussion in Chile as well about changing the constitution and the heavy-handed issue on rights of nature and the roles of the state. And well, we have, in terms of climate litigation, the pace has been slow in our countries. Few cases with the impact of Urgenda, Client Earth, or Ashgar Legari, for example, are seen in the region, although we have an outlier, just the case they refer the students, the case of Colombia, the Supreme Court in Colombia. However, what we are observing is that climate litigation is increasing, but with an idiosyncratic twist in Latin America, because most of the cases are against the poor performance of the states in many spheres of environmental protection. In Latin America, as in many continental law countries, legal tradition is very exegetic still. Hence, if the law does not provide explicit solution about climate change, courts tend not to innovate. However, starting from this ecocentric legal paradigm, that courts are adopting two new approaches. Either they interpret environmental provisions in favor of ecosystems, and we are using, and it's very common, this in dubio pro natura in Latin America, or directly, this is another way, they interpret the law under the ecocentric perspective, creating new rules, which is the case of the Supreme Court in Colombia, in Ecuador, in Bolivia. So we have here examples about in these two areas. We have cases in Chile and in Argentina where the Supreme Courts have interpreted that companies are obliged to pursue the protection of the environment, basically because they are under the cover of their environmental license. So we don't have the same litigation experiences like in Europe. And in the case of the ecocentric paradigm, we see the Colombian Supreme Court as one example of this protection of the Amazon in the light of the ecocentric approach. So what we are seeing in terms of private litigation is that usually the cases are against private companies based on their environmental license. Communities are requesting judicial review on those licenses in different fashions. For example, indigenous people are arguing based on the FAO Convention 169, for example, they are arguing on that regard. And we see that based on the ecocentric gist of Constitution, they are building their cases on human rights as well, starting from the Constitution. So with no further ado, I will rest my case there, Andres, just to respect your 5 minutes time. Thank you.
Thank you very much for this first insight. And I'm sure we will come back to points that you raised. And but let's go straight to the second panelist, which is Bernard Namanya, he is a climate change law consultant at BNB Advocates in Uganda. Bernard, the floor is yours.
Okay, yeah, thank you for the opportunity to share my thoughts on the topic of private climate litigation. I'm here to share the Africa perspective on the topic. My thoughts are organized around two main areas. Number one, I will provide a quick overview of private climate litigation in Africa. Number two, I'll briefly discuss some of the potential drivers of private climate litigation in Africa. I'll now proceed to tackle the first major area, which is the overview of private climate litigation in Africa. According to the Sabin Center Climate Litigation Database, there are 13 climate litigation cases in Africa, and about 5 of them involve private corporations. The 5 cases that involve private corporations include Earthlife Africa versus Thaba Messi Power, Sustaining the Wild Coast versus Shell, South Durban Community Environmental Alliance versus Sasso and Eni, Save Lamu versus Amu Power Company, and Gibemi versus Shell. All of these cases relate to the fossil fuel industry, and that is to say coal and oil and gas. 4 of the cases relate to the failure to conduct climate change impact assessment during environmental impact assessment approval process, while 1 case concerns enforcement of fundamental human rights. In terms of geographical distribution, the 5 cases are shared by 3 African countries, and that is South Africa, Kenya, and Nigeria. I'll now proceed to tackle the second main area of my presentation, which is potential drivers of private climate litigation in Africa. Private climate litigation cases in Africa are significantly lower than those in the global north. However, my thinking and my prediction is that private climate litigation cases in Africa will continue to grow in the near future due to 4 main factors. The first driver is emerging climate change laws in Africa. Some African countries have adopted climate change laws that are likely to drive the growth of climate litigation cases. In Uganda, for instance, Section 26 of the National Climate Change Act 2021 provides for climate change litigation against private entities. In Kenya, Section 23 of the Climate Change Act 2016 provides for climate change litigation against private entities. The 4.2 of the Climate Change Act 2021 provides for climate change litigation against private entities. The second driver is lessons from successful climate litigation in the global north. The success of climate litigation cases in the global north is likely to influence the growth of private climate litigation in Africa. For example, the success that we have witnessed in the case of Milieudefensie versus and others versus Shell in the Netherlands, where principles established in the agenda decision for holding governments liable for inadequate climate action were extended against a private corporation, that is, say, Shell, is likely to drive further litigation against private corporations in Africa. The third driver is the possibility of using the human rights approach to climate litigation. The human rights approach to climate litigation enables litigants in African countries without enabling legal frameworks to pursue climate litigation cases by invoking human rights legal provisions and applying them to a climate change context. A good example is the Gbemwe versus Shell case in Nigeria that pursued the line of enforcement of fundamental human rights in relation to Shell's oil and gas flaring operations in Nigeria. The fourth driver is NGO activism. In many of the cases that I have cited, we see that NGOs have been behind the success of the cases. For example, in the Save Lamu and Earthlife Africa cases, NGOs played a prominent role in running, financing, and prosecuting the cases. This trend of NGO activism is likely to continue to grow. In conclusion, while private climate litigation cases in Africa are currently low, my prediction is that they will continue to grow, partly due to the drivers that I have highlighted in this presentation. I thank you for listening to me, and I look forward to engaging further with you in the question and answer session later on. Thank you so much.
Well, thank you, Bernard, for this very concise overview and your perspective on various African countries. And there are you mentioned a few very interesting points that we will for sure come back to in the discussion. And thank you also for mentioning the Dutch case against Shell, which we'll probably also come back to in the discussion. And as you mentioned, this case has importance well beyond the borders of a country, and that is already sort of a difference to litigation against states, because as we know, corporations are often multinational corporations with operations globally. And so thank you for mentioning that, and for sure we will come back to this aspect later. Which brings us to our third panelist from Italy. We are very glad to have Carolina Piovano with us. She is the Senior Associate at Clifford Chance in Italy. Carolina, we are looking forward to your perspective on Italy.
Thank you very much, and good afternoon, everybody. So first of all, let me thank Antonia and the Sabin Center of Climate Change Law for this huge opportunity to speak in this very interesting conferences with all the speakers from all over the world, which gives you a perfect insight of what is climate litigation. What I want to talk about in my 5 minutes talk is greenwashing. Greenwashing is becoming very famous, and I believe it will be the future litigation trend which companies will be facing in Italy as well as in other parts of the world. But I chose this topic because in Italy we have 3 cases that gives you concrete examples of the 3 potential liability a company may face when making inaccurate or false green claims in relation to its product or its nature or its business. As you may know, greenwashing is a practice of marketing a company or a project so they appear more environmentally friendly or more ecological than they actually are. We see claims everywhere, such as 100% recyclable, 100% green, or the most environmentally friendly product. So we see that everywhere in the advertising campaign. And so green claims are often used in marketing and as a mean also to gain more customers and to sell more product, because we see nowadays that consumers and customers are more aware and wants to buy more green products because they are aware of the impact on the environment of particular products. So as a consequence of such a huge huge use of green claim, it's becoming more and more frequent to see those claims to be scrutinized and sometimes be proven false or inaccurate or a mere exaggeration of some of the quality that a product have. And if so happens, greenwashing can be seen as an unfair commercial practice. And so corporates or company making such a green claim needs to be aware of the litigation risk that they are potentially facing. In my opinion, such risk is at least against 3 different players, namely local competition watchdog, consumers or customers in general, and competitors. And what I'm saying is not just speculation. As I told you at the beginning of my talk, in Italy, we had 3 recent cases which perfectly fall into the above 3 categories. So let me elaborate a little bit more into this concept. So first, as we said, the corporate may be the defendant in proceeding brought by the national competition authorities for misleading advertising. Such proceedings can end up, for example, in huge fine for the defendant. An example of this liability is the case regarding a famous Italian oil and gas company, Eni, which was mentioned by the Niamara before, which was found to have violated the unfair commercial practice European directive with its Green Diesel Plus campaign. The company was condemned to pay €5 million fine, so a huge amount. The case is still pending because Eni appealed the decision. Secondly, we said that the company may face liability against customers. And in fact, the green claim can expose corporates and potentially also their directors to claim brought by consumers, customers, investors, or shareholders in general, who are able to prove that they have been persuaded to buy or invest in a particular product by misleading green marketing. Also, an example of this case, it's in Italy, and it belongs to the Italian stream of the Dieselgate saga, and in which everybody knows that a famous German company, which is Volkswagen, and in Italy, its Italian subsidiary, were found liable for misleading advertising in a class action brought by over 60,000 consumers, represented by a local NGO, claiming to have been induced to buy a particular type of car for its green qualities that were at the end proven not to be true. In this case, the court awarded damages under total law amounting to €3,000. The third type of liability is instead against competitors, because at least under Italian law, but I bet in other countries too, unfair commercial practice may sometimes also constitute an act of unfair competition, in so much it entails unlawful competitive advantages to the detriment of other companies. And we have also in Italy a case on that, where an Italian company sued another Italian company and requested interim measure to stop such a second company to make green claims, arguing that with this claim, the claimant was losing market share. So my view here is that greenwashing may really expose the company to potential liability. And we have three material examples of this. Sorry, I was a little bit longer, but I hope it was interesting.
Thank you so much, Carolina, for this very interesting perspective on greenwashing, which, as you describe, is one interesting and important aspect of in this whole private climate litigation trend, which we see globally. And I'm sure we'll come back to various points that you raised as well. And as you mentioned, there is already enforcement in Italy on greenwashing claims, as you mentioned, with this 5 million fine. So that's a very interesting development. Thank you for pointing that out. And as Maria Antonia mentioned in the chat, so that is for the participants, please feel free to just write all your questions and or comments in the chat, and we'll have a look at them later. But first we will go to our fourth panelist, that is Conrado Cornelius. He works at the Joko Suitono Research Center at the Faculty of Law at the Universitas Indonesia. And he will share his perspective on Indonesia. Please, Conrado, the floor is yours.
Thank you very much, Andreas. I'll share my screen with just a brief slides. Wait. Yep. So I'll be presenting about the trends of climate change litigation in Indonesia. So this is based on a book chapter which I co-authored with a colleague of mine and was published by the end of 2020, if I'm not mistaken, by Cambridge University Press. So in this book chapter, we call the Indonesian strategy of climate change litigation as climate change as a secondary litigation. So in many parts of the world, especially in the global north, the early cases of climate change litigation, tort-based climate change litigation, has often been unsuccessful when faced with common tort law doctrinal challenges, establishing a breach of duty of care, causation, and damages, and so on and so forth. Now, what is interesting about the Indonesian strategy is lies not in how it addresses or solves these doctrinal challenges, but rather in how it provides a way for plaintiffs to avoid these questions altogether. So the cases which we call as climate change as a secondary litigation were not exactly a climate change litigation as such. At least they were not primarily about climate change. So these cases were instead primarily about wildfires and illegal logging torts. And in all of these cases, the plaintiff has always been the state, represented by the Ministry of Forestry, of Environment and Forestry, and the defendants has always been corporations. The plaintiff has sued the defendants for the environmental damages occurring on their concession areas due to either wildfires or illegal logging. Well, there are a number of scenarios, but I will not go into further details about it. But simply put, as part of the compensation value that the plaintiff demanded, the plaintiff also accounted for the carbon emission associated with wildfires, and also the loss of forests' carbon sink capacity in both wildfires and illegal logging cases. Now, these cases have always been sued by the plaintiff under either unlawful act liability rule, under the which is known as perbuatan melawan hukum under Indonesian law, which is similar, analogous to negligence liability rule under the common tort law, or I guess, but since Indonesia is a civil law country, perhaps it has more affinity to other likely continental tradition legal system, like the Dutch, for example, or the German, as well as strict liability, especially on wildfires occurring on peatland areas. and the way carbon emission is being valued is 90,000 rupees per ton carbon. I guess it's like less than $10 I guess, based on today's exchange rate, if I'm not mistaken. So these are the list of cases, which some of them have been updated in the Sabin database. These are wildfires and then illegal logging. There are only like so far 2 illegal logging cases. Some of which, for example, in the case of the first case, Selat Nasik Indokuarsa and Simpang Kosak Indokuarsa, it's also associated with irresponsible mining activity. It's not illegal, but there are some certain administrative violations. Now, what makes climate change a secondary litigation in these cases is because climate change only entered these cases when accounting for the total compensation value that the defendant should pay, and climate change is being counted when the plaintiff is asking for the compensation for the restoration of forests and restoring the carbon sink capacity of the forests. Additionally, it's also important to note that arguably both the judges and courts may perhaps be oblivious to the fact that they were actually examining and deciding a climate change litigation case. Now, from a theoretical perspective, the Indonesian climate change litigation strategy can be said as a form of peripheral climate change litigation, in that it's not, these cases are not exactly or centrally about, it's not focusing on climate change. In fact, there are no climate change arguments in all of these cases. What makes these wildfires and illegal logging cases also climate change litigation is also only to the fact that carbon emissions from the defendant are being accounted in the accounting of the total value of environmental damages that the defendant should pay. The Indonesian experience can also be said as a form of implicit climate litigation, where plaintiffs are bringing climate change cases with certain connection to some aspect of climate law or regulation, but without a mention about climate change as a strategic attempt to avoid judicial refusal. Perhaps this is also similar to Professor Domas's remark that in a civil law tradition, when things are not explicitly provided under the law, that may discourage courts, judges to apply, say, a sort of progressive or a novel legal norm.
Conrado, oh yeah, thank you. Sorry.
That is all from me. Thank you very much.
Thank you so much for this perspective, Conrado, on Indonesia. My main takeaway was, and I'm sure we will come back to that, is that often these cases will be related in some way, as you mentioned, to logging, illegal logging or other forms of problematic logging. Thank you for that. And now let's move around the globe to Canada, to our fifth and final panelist. It's my great pleasure to welcome Tyson Dyke, partner at Torres LLP in Canada, to share his perspective on Canada and I believe also the US.
Thank you so much, and a big thank you to the Sabin Center for setting up the conference. It's a wonderful opportunity for folks around the world to gather together to discuss this important topic. My co-panelists have done an excellent job in describing many different avenues of private climate change litigation, which are becoming increasingly prevalent today. I'd like to use my 5 minutes not to talk necessarily about the avenues of climate change litigation, but instead about some of the actions that companies can take to mitigate the litigation risk, which is becoming increasingly important to them. In Canada here, we haven't seen a lot of climate change related litigation. There has been some actions brought, some judicial reviews of licensing decisions, some private climate change complaints that are working their way through the courts, but certainly not the same volume of litigation that we see in the US, where there are many sophisticated ENGOs with large endowments devoted to climate change litigation. But this is slowly changing. The litigation trends in Canada tend to follow what's happening in the US, whereas we know we have seen several high-profile cases. But even though we haven't seen a lot of climate change litigation here in Canada, many Canadian companies are still proactively evaluating and managing the risk of this litigation. And I think there are a few main reasons why. Many Canadian resources companies, as many other resource companies around the world, have an international footprint with global operations and supply chains. And they're very concerned with potential liability or reputational exposure for their parent company and their subsidiaries in light of some of the cases that have already been discussed today. As well, many Canadian banks and pension funds provide financing internationally. And although their scope 1 and 2 emissions tend to be relatively small for those types of organizations, their scope 3 emissions, especially in relation to financed activities, can be very significant. And many of those banks and pension funds are concerned about the litigation and reputational exposure of their investment vehicles, and many of which are in oil and gas or natural resource operations. So these companies are watching litigation trends very closely. And, you know, I think when it comes down to it, there are more and more steps being taken in the marketplace, especially in the context of these risks, where companies are looking at the nature of some of these claims and trying to think about what they can do proactively to mitigate and manage the risk. And I'd put the topics of these actions in two main categories. First, there's been a number of actions taken on climate disclosure. As well, there's been a number of actions taken on establishing climate change mitigation action plans and implementation plans for GHG reduction targets. So let's start with disclosure. How are companies managing litigation risk through improved disclosure? You know, first, I think many companies are finding they need a methodology. There are many standards out there by which companies might adopt a climate change disclosure framework, but many of those standards are coalescing around the task force on climate-related financial disclosures. In some cases, that framework is being imposed through securities legislation. In other cases, companies are adopting it voluntarily and supplementing it by corporate-specific disclosure standards like the GHG protocol or SASB standards. But I think it's important for these companies, and they're finding it more and more, to get a framework in place by which they can start having a systematic approach to gathering data and disclosing that data to the public. The data collection itself is straightforward in some cases for resource companies that have been required to report on certain emissions for years. They have established processes in place to do that. But for other companies, it's a difficult task that they haven't devoted much time and energy to in the past. For a number of investors who are now trying to start reporting scope 3 emissions, they're finding that scope 3 data can be very unreliable. It's essentially someone else's scope 1 and 2 data. And so if you're a bank looking to disclose financed emissions data, it raises a whole host of questions in terms of how you can reliably collect that third-party data. There's also a question about how to disclose that data appropriately. And from a legal perspective, you know, given some of these uncertainties and challenges, it's important for companies to ensure that their climate change related disclosure is appropriately qualified to help avoid some of the greenwashing claims that were discussed earlier. It's one thing to gather the data, but when we're presenting it publicly, companies need to make sure that they're doing so transparently, but also with any appropriate caveats for the public to see, to ensure that they have a reliable understanding of the information presented to them. And finally, let's just turn to climate action for a minute. You know, how can companies mitigate climate litigation risk through climate action plans? I think, as we've seen in the Shell case, many litigants will not accept any action. More and more, they want to see credible and concrete long-term and interim climate change and GHG reduction targets. There's also been more and more criticism about the robustness of net zero targets and claims. So I think a lot of the companies that we work with are trying to take very methodical steps to ensure that the targets they're setting and the action plans that they're developing have rigor and can withstand any litigation challenges. And how are they doing that? I think at first, they're trying to set science-based targets. It's not just a matter of saying we want to be net zero by 2050. It's developing a model that shows how they can reduce their own greenhouse gas emissions in line with global modeling and pathways that are scientifically credible as ways to try to limit global temperature increases to 1.5 to 2 degrees Celsius by 2050. I think companies are also taking that longer term projections and breaking it down into shorter term action plans to give the public or investors confidence that they have credible milestones along the way to those longer term targets. And I think finally, and it's probably the last point I'll make, is that many of these companies are looking at offset credits as a way to balance their greenhouse gas emissions, but they're doing so with a healthy degree of skepticism. I think the market for voluntary offset credits is set to explode, but there remains many risks associated with these credits. There's been many claims that not all of these credits have been created with equal environmental integrity. There's been claims about fraudulent credits being issued in the past, and many credits not being worth their weight, so to speak. But I think companies are appreciating that risk more and more and focusing their emissions reduction efforts on what they can do internally first before they look to use offset credits or carbon removal credits to help balance their emissions. And that approach is more and more consistent with what we're seeing in terms of the Oxford Principles for Net Zero Aligned Carbon Offsetting and the Net Zero Banking Alliance, which all really try to encourage internal emissions reductions before sourcing those offsets elsewhere. So I'll pause right there and again thank the co-panelists and Andreas for hosting this session, and I look forward to the discussion.
Excellent, thank you very much, Tyson, for this fifth perspective, which brought up many interesting points again that set the stage for the Q&A session, which will begin now, and we have almost an hour to discuss. I didn't see much activity in the chat yet. Perhaps participants are a bit tired from the previous panels, but I'm sure questions will come up, and do not worry, I have many questions if not. Perhaps to start to go, so we have spoken about so many aspects already or briefly touched upon them, but maybe let's go one step back, and I want to ask the panelists, from your experience, who are in private climate litigation, who are the typical plaintiffs that you see or that you expect to see in the future if you don't have any cases so far in your jurisdiction? And I would like to start with Professor Michael Handke-Thomas.
Oh, thank you, Andreas. And well, on that regard, what we see is that communities are increasingly gathering forces in terms of hiring NGOs or dealing with NGOs in terms of submitting claims against companies, usually their licenses. So this is one trend. The other trend is the same state as well, okay, where the state claims against private companies because of environmental damages. There's an important case in here in Chile where a Canadian company had an ore mine, and they destroyed part of the glacier. Well, the company at the first instant, it was sued by the community, and the company used the climate change defense, so which is different what we are talking here. So the company argued that the whole glacier was melting because of climate change, and the court agreed with the company. So the case was lost, but by the end of they followed in different claims as well afterwards, and finally the mine was closed, and all the capitals were went back to Canada and Argentina. So this is one of the trends that we see is either governments or communities that are submitting claims against companies because of in different fashions climate change issues. Although the climate change main issue, like in Milieu Defensi versus Shell, is different. In our case, that was the main issue here. Usually, the climate change is an additional issue. It's not the main driving of the action.
Thank you so much. Let's move to Bernard, who are in African cases. Who are, I think you touched upon it, but can you comment on that again? Who are the typical plaintiffs in climate litigation against private actors or corporations in your jurisdictions?
Okay, yeah, thank you. In African cases, those concerning private players, we see that most of the actions are driven by NGOs, and I'll cite two examples: the Earthlife Africa versus Thaba Messi Power, a South African case. We see that this was a case largely driven by an NGO. In Kenya as well, when you look at the Save Lamu versus Amo Power Company, this again was a case that was driven by NGOs who mobilized finances required, provided the technical expertise, and to ensure the successful prosecution of these cases. So the brief answer is that we see a lot of NGO activity in driving these types of cases.
Thank you very much. And would these be, let's say, local NGOs or global NGOs?
It is a combination of both. You have local NGOs working in collaboration with international NGOs, and yeah, so it's usually a combination of so many of them. So local players together with international NGO actors.
All right, thank you very much.
Yeah.
Carolina, how about Italy? Who's a typical private climate litigation plaintiff?
So at the moment in Italy, we don't have any proper climate change cases. So we don't have any cases such the Shell case. We only have the case brought against the state, such as the Urgenda. But at the moment, against private company, there are none. The only cases which are climate related are the one that I mentioned on greenwashing, but the climate issue there, it's on the background, is not the main purpose. If I have to think about a trend then for the future, then I would say that NGOs will be the one to bring up claim against private corporation, and both local, but I believe maybe more international one, maybe try to import cases that have been successful in other countries, such as the one against Total or against Shell, because it will be easier to do it in the civil law countries as well.
Thank you, Carolina. Conrado, are NGOs also are the main plaintiffs in Indonesian cases, or are there other categories of plaintiffs?
Well, I think the Indonesian experience is quite unique. Unlike in other countries, for example, where states have most often been defendants, like the case of HENDA, Massachusetts versus EPA, and so on and so forth. In the Indonesian experience, apparently the plaintiff happened to be the government itself. But this should not necessarily mean that the Indonesian government is, say, environmentally progressive. It's just perhaps it is something, for example, in illegal logging and wildfire cases, the fact that somehow climate change entered the court was perhaps because the Ministry of Environment and Forestry is somewhat being updated with recent climate science. So, for example, they obviously have a team of scientists inside the ministry, and they now realize that there is a connection between wildfires and climate change, and that seemed to be a logical choice when to include liability for carbon emission in the compensation value demanded by the government. Now, we also have in Indonesia other types of plaintiffs. We also have NGO lawsuits against corporations, but they have not been successful. For example, we have and the case has been included in the Sabin database. We have a case by Greenpeace Indonesia suing the government of I think it's the governor. So no, it's the region or governor of Bali on a environmental permit issuance. So the plaintiff argued that the issuance of the environmental permit is illegal because it did not consider climate impacts in the environmental impact assessment, which is the underlying document for the issuance of environmental permit. But while the argument is quite advanced, unfortunately the court dismissed the plaintiff's lawsuit because the court deemed that the plaintiff lacked legal standing because the plaintiffs do not have direct legal interest on the case because it's because of the environmental permit. Usually the party that has a direct legal interest to the license will be the should have been the license holder, but in this case it was the NGO, and somehow the court decided that, well, because you're not the license holder, then NGOs do not have a direct legal interest to the case. But in the future, I guess there will be more and more NGO lawsuits against either private parties or against government bodies or organs. So I think that's the case for Indonesia.
Thank you, Conrado. And finally, I'll invite Tyson for his comments. Maybe also you want to add a bit more detail about something you already touched upon, which is the role of shareholders and their role on increasing climate litigation risk, as you mentioned. Tyson.
Sure, thank you. I think there are a few main categories of plaintiffs or claimants that we see in Canada. The first has been discussed, it's NGOs, and a lot of the novel climate change litigation, especially tort-related litigation brought in Canada, is brought by NGOs and very rarely by individual plaintiffs. It's often very costly to bring this litigation, and many individual plaintiffs do not have those resources and instead rely on an NGO to bring forward the claim, even if the underlying action is derived from some damages experienced by an individual. I think a second category of claimant is typically a nearby landowner or community, and it could be an Indigenous community. And often we see these types of claimants in relation to the types of secondary climate litigation that have been discussed, especially when it involves the licensing of a facility that might have some environmental impact that is climate related. Often the subject of those judicial review applications or licensing challenges are brought by proximate landowners or Indigenous communities who raise climate change concerns among a number of issues in their challenges to governmental licensing decisions. Now, that's often because of standing issues, and those communities are the ones with the appropriate standing to bring those types of complaints. And Andreas, to your point, I'd say a third category of claimants, might be the shareholders of a company themselves. More and more, we're seeing activist shareholders who are bringing forward shareholder proposals, trying to force companies to take certain climate-related actions. I think a lot of those shareholder proposals in recent years have focused on improving climate change-related disclosure. More and more as companies are improving their disclosure and adopting voluntary disclosure frameworks, or being obliged to meet securities law regulations in terms of their climate change disclosure. Many of their shareholders are putting forward proposals to have the corporations that they invest in take certain climate change related actions, whether it's setting targets, developing climate change action plans, taking certain implementation measures. You know, the number of activist shareholders that are trying to seek and affect change in that fashion are increasing as well.
Thanks, Tyson. If we don't have any still don't have questions from the chat, I will introduce
Andreas, sorry,
yes?
we have some questions. If you
okay.
go to the
Sorry.
Q&A section, we have 3 questions
I'm very
for
sorry,
the panel.
Okay.
Can you see them?
If you want, I can read.
Please, if someone can help me here, I cannot see them on my screen, unfortunately, so please.
Okay. So the first question is with regards to litigation cases against companies that are working on the African continent, are the rulings having an actual effect on the activities, or due to various procedural issues such as lengthy nature of legal proceedings, the absence of legal standing opportunities, lack of clear causal links, the effects get lost and derailed?
Thank you. Now I can see it. Yes. Who wants to reply? Please just speak.
Yeah, I can attempt a reply on that. And yeah, so that's an interesting observation, because the litigation in African courts tends to be lengthy and protracted. So cases can take as long as 10 years in the system before you get a final judgment. So the observation is correct that many of these good cases can get lost along the way. However, if I'm to look at the 2 cases, one in Kenya, Save Lamu versus Amo Power, a coal project, we see that in that case, the court, the tribunal, the environmental tribunal issued basically revoked the environmental authorization for the project. And as a result of that, I think the project has kind of stalled, and as well as some financials have withdrawn from further supporting that project. So if you look at it in that context, then you can say that there has been some kind of result connected with the litigation. In South Africa, the Earthlife Africa case, which is against the Thabamesi coal power project, again, we see that as a result of the challenge to the environmental authorization for the project, we see that the project again there stalled. And I think some financials have as well withdrawn from that project. So viewed from that context perspective, you can argue that there have been some results. However, that does not take away the general concern that many of these cases then take so long in the system, and so as a result, discouraging would be litigants. That's what I can say about that.
Thank you very much, Bernard. Does any of the other panelists also want to reply? To this very comprehensive answer. Otherwise, we'll go to another question in the chat, which was written by Emily Coutin to Carolina and Tyson. When considering the types of companies at risk of liability for greenwashing, or generally, what types of companies are we talking about? Are we mainly considering companies in specific industries, large companies, multinational corporations, etc.? Or does this topic also extend to smaller companies and across all industries? Carolina?
Yes, thank you. Thank you very much for the question. From my experience, I think no companies are free from liability, and especially in Italy, the cases that are involving companies for allegation of greenwashing are both big corporates like Volkswagen or Eni, and small company, because the last greenwashing cases brought by a competitor against another one is brought by a smaller company. So there's no definition, no sides of a company. As well industries, because everybody can market a product by enhancing its green features, and it doesn't matter the sector on which this company, this product, is marketed. So I think also the fact that oil and gas company will be the most affected in climate litigation, it's no more actually true. So every companies can be brought into trial. I don't know what Tyson think, but I think this is at least my experience.
Thanks, Carolina. I mean, I agree. I think it's a risk for all companies. I would only add that I think the risk is relatively higher for companies that operate in more carbon intensive sectors. And I think that's the case because a lot of this litigation is strategic litigation. It's expensive to bring. In some cases, it's brought designed to achieve, corporate change, to bring forth reputational concerns about a company that might not be doing its fair share to address climate change related impacts. And in that sense, when plaintiffs are considering which company to bring this type of greenwashing claim against, many plaintiffs will choose companies that have the highest profile, that in which the litigation might gather the most news headlines and so on. And in often cases, those are large oil and gas companies, at least here at home, or other companies that are operating in carbon intensive sectors that do have a lot of news and press to go along with their activities. In those cases, the strategic litigation can have a bigger impact and have more repercussions for the industry at large. In just one example here in Canada, Greenpeace had brought a claim to our Competition Bureau in Canada, alleging greenwashing claims against Shell Canada. Shell Canada had offered a program at its gas stations where it had said to its customers that you can be carbon neutral by filling up your cars and vehicles with gasoline bought from our locations, because we are investing in a carbon offsetting project in British Columbia, Canada. Greenpeace alleged that carbon offsetting project wasn't actually achieving the acclaimed emissions reductions that Shell Canada was suggesting it did, even though those emissions reductions had been certified by well-regarded voluntary offset standard. But I think that litigation or that complaint was brought against Shell Canada, not because Shell Canada is the only company that has exposure here, but because it was a big target. And in terms of the strategy of the litigation, I think those big targets are often front and center because of the reputational impact and repercussions for the broader industry.
Right, thank you very much, Tyson and Carolina, for these further insights. I have another question, good question in the chat from an anonymous participant. Could you please indicate bibliography to deepen the subject that I can reply to? There is a lot of literature for you to read, and perhaps just look at the Sabin Center's website and start from there, and you will see. Start from there, and there will be a lot of literature for you to go from there. And the question I would like to pose to the panelists, maybe Michael and Conrado, is a bit general. What can you elaborate on the main challenges in litigation against companies? And is it more strategic to litigate against states? Perhaps Michael first.
Yeah, well, thank you for that question, Andres. Well, it will depend on the type of action. So for example, if you go for tort law case, it's very difficult. It's a difficult way, not just because you have to prove whatever your action, but as well it's very expensive in some cases where companies tend to hire very big guns for this kind of cases. And although judges are aware about this problem of experts giving evidence in courts, still there are some rules on adjudicating the case. And there's another issue that I would like to raise as well, is the ability, the steep curve of learning environmental law. This is another issue that many people are not aware of. That means that you can have a very sophisticated regulatory framework for environmental protection, but usually lawyers do not pursue courses, at least in Latin America, pursue courses on environmental law, but when they leave university and they do their master's degree, for example. So that entails as a barrier for access to justice, and we regard this as a big problem in Latin America. This is one big issue, and well, that's on environmental tort. On judicial review, probably is easier, as usually the discussion is about a law issue. But still, you have to face different problems in terms of strategy. Well, as Tyson mentioned, usually you go against the big shots and the big companies because it's easier, and you can have, for example, probably nobody has raised this issue, but about funding. This is another problem. We are increasingly seeing in Latin America the landing of litigation funds, which is a very different. It's a game changer probably, but this is the inception of that trend, and therefore probably that might help to raise these actions against companies and governments as well on that regard. Thank you, Andres.
Thank you very much. Conrado?
Thank you for the question, Andreas. Well, in the Indonesian context, so I think there are, I have two answers to your question. So the first is, if the type of case is, say, a tort lawsuit, then as I've already explained in the Indonesian experience, then plaintiffs should be somewhat smart. In a way, you're doing some innovative strategy to win their case, which is the case of climate change as a secondary litigation. But when, say, private entities, or like NGOs or private persons are suing against corporations, then perhaps tort law may not be the ideal legal avenue to be pursued by plaintiffs. Now, another likely strategic scenario is, say, suing the government for regulatory action. This may or may not be successful in the Indonesian context. So in the Indonesian experience, a number of articles have been written about this, and it's also written in English. So perhaps if you would like to read that, it has been published actually in the Journal of Environmental Law about rights-based environmental judicial review. So part of the challenges for doing, say, a rights-based climate change litigation, just like environmental judicial review, it may be the fact that courts in Indonesia are quite hesitant to apply rights-based arguments in their judgment, because it is somewhat of a prevalent point of view on human rights, that when say a state is being deemed to have violated human rights, it's just something that is so bad. It is evilish, perhaps, because somehow in the amongst Indonesian judges, human rights violation is always reserved to, say, the traditional Rome Statute violation, genocide, war of aggression, and so on and so forth. And it's quite alien to the mind of Indonesian judges that there could be another form of human rights violation. And these are deeply politicized amongst the Indonesian, within the Indonesian judiciary and also the larger public. So that might be a challenge in the Indonesian context. That's for me, Andres.
Thank you, Conrado. We have more very good questions in the chat. I believe the next one, yeah, I'm having a bit of trouble seeing it, but I believe the question was about shareholder litigation. If we have any examples, does any of the speakers want to mention some? I know some examples from the US, which is shareholder litigation brought against the fossil fuel company ExxonMobil, where shareholders alleged that they were damaged due to, in the end, misrepresentations as it relates to the climate risk exposure. Tyson, are you familiar with these cases and can comment a bit on them?
Sure, I'm happy to. I mean, I think that Exxon case that you mentioned is probably the most high-profile case. That was a shareholder derivative lawsuit filed against Exxon in New Jersey. It, as you mentioned, related to an assertion that Exxon had misrepresented some of the climate change costs that it was incorporating into its disclosures. You know, I think at the end of the day, a lot of the shareholder litigation does relate to some form of greenwashing or negligent misrepresentation. I think investors, you know, under the various corporate statutes at play here, have a right of reasonable expectations that, you know, the information that they are basing their investment on is accurate and provides material disclosure to them. So the Exxon series of cases and actions really focused in on that. There's some more cases coming out of Australia that I do believe are on the Sabin Center website as well. There's one on the Australasian Center for Corporate Responsibility versus Santos. Again, that was another greenwashing type of claim brought by shareholders under the relevant corporate statute. Abrahams versus Commonwealth Bank of Australia was another case, again, brought under the applicable corporate legislation, but it allowed shareholders of the company to apply to the court to make an order authorizing those shareholders to inspect the books of the company. And in this case, that inspection was in relation to their climate change risk assessment process, among other things. So those are just a few examples, but I would encourage folks to check out the Sabin Center website, because I do think that there's a number of cases listed and summarized there.
Right, thank you very much, Tyson, and also thank you for mentioning the database, which is very helpful to get a quick overview of what's going on around the world, and that is regularly updated. And also for highlighting Australia, which we have not been spoken about today because we don't have a panelist from there. But in Australia, there is a lot of shareholder activism around these climate topics, especially fossil fuel and financial sector, as Tyson mentioned. Thank you very much. Now I jumped one question by Florian Wexlauk. We do not want to miss it because it's a very good one. His question is, do you see it as a problem for the effectiveness of private climate litigation that companies can move their activities or headquarters to other countries' jurisdictions? Whoever wants to reply, please feel free.
I can take a crack at it, although, you know, it may not be within my expertise, but I would just say at a high level that I think it depends on what the goal of the litigation is. You know, I think if the goal is to, you know, pursue damages as a result of the parent company's operations, there may be standing issues to the extent that parent company moves to a different jurisdiction than the plaintiff resides in. But if the goal of the litigation is to bring forward awareness of corporate behavior, I think even in cases where a parent company might reside in a different jurisdiction, but a subsidiary operates in a local country where the litigation is brought, that reputational impact can still be felt.
Right, thank you.
Yes.
And yeah, please.
Yeah, no, I agree. And also from a procedural point of view, if the defendant is from one jurisdiction, and for example, in that jurisdiction, you have a parent company, but the headquarters are elsewhere, you can still try to work out with procedural rules to sue both company and to make them stay in the jurisdiction of the claimant. So it could be a way to avoid, in some cases, liability. But if you are a big company, especially, for example, Shell, it could be sued either in the headquarters in Netherlands or in Canada, as we saw with Tyson. So maybe it could be a problem when, for example, the headquarters are in a tiny country with like a paradise, but I think you can still work it out and try to sue the company, make them join a pending proceeding elsewhere.
Right, thank you. And at least as soon as you have launched the proceedings, at least in those jurisdictions I know, you have the effect of lease pendens, which means that the case will remain in that country, right? But it's
exactly. Even after, if you change the headquarters in a second moment, then the proceeding will remain in the first in the country that you chose.
Right, as we now see in the Shell case, right? Shell has announced to move its headquarters to the UK. So maybe Florian was thinking about that instance. Good. A bit, Bernard, I want to move to you. Do you have thoughts to add about, as we mentioned initially, you know, these companies operate globally. They can sort of move around certain activities. From your perspective, how does that impact litigation in the jurisdictions you know?
Yeah, thank you for that question. I will not differ much from the previous panelists. I think that if litigation, if a company moves its headquarters in the face of the upcoming litigation, then the point can still be made as to why those maneuvers are being done to escape liability. So the previous panelists, one of them, someone mentioned the reputational impact will still be felt. So I think that even if that move is taken, the impact will still be there. So I think it may not be, well, they may avoid some form of liability, but at least, but at the same time, they will still feel the reputational impact of their maneuvers.
Thank you very much. Do Michael and Conrado want to add something on this point?
Yeah, I think it's not free the move of Shell to the UK, because probably on the remedies might be a way of escaping them. So, so for example, if a court in the Netherlands decides upon a remedy against Shell, and Shell moves the headquarters to the UK, probably to make it compulsory for Shell in the UK might be a bit difficult. So the proceedings of bringing that action against a company living abroad might be more difficult. So, so I think that's that might be one of the explanations. Although they will have a bad reputation and all the, I agree with all the comments here. Still, this is a strategic move, and I think it's related with the decision and how do you implement the decision.
Thank you very much. Conrado, do you want to add something on this point?
None from my side.
Okay, thank you. Then we'll go to another very good question in the chat, again by Emily Coutin, about Scope 3 emissions, which Tyson spoke about in his presentation. So here we talk about indirect emissions, which, as was mentioned, usually represent the large majority of total emissions of a company. I believe in the Shell case, around 85% of that company's global greenhouse gas, or at least CO2 emissions, are Scope 3. So these emissions, as pointed out in the question, are rarely included in emissions reductions target. Given the difficulty of measuring them, what can we reasonably expect from governments or private actors in terms of disclosing, reducing, and or being held legally responsible for Scope 3 emissions? Let's start with Tyson.
Thanks, and it's an excellent question. You know, I think we are seeing some shifts around what's happening with Scope 3 emissions. I think, you know, as Andreas mentioned in the Shell case, a real focus there was for Royal Dutch Shell to take responsibility for Scope 3 emissions. We're also seeing a number of major financial institutions look at their Scope 3 emissions, especially their financed emissions, and develop targets that start to address those Scope 3 emissions. And it's not just like flipping a switch. It doesn't happen immediately, because there are certainly some challenges in collecting the appropriate data from investments, from and a lot of the methodological concerns are real concerns to make sure that that data is of good quality and can be reported transparently. But we are seeing major financial institutions like JP Morgan and Morgan Stanley look at Scope 3 emissions from their investments in the oil and gas sector, in the power sector, in the transportation sector, and set targets in respect of those emissions, as well as their own Scope 1 and 2 emissions. And I think, you know, what can we expect in terms of Scope 3 emissions? I think we have to, you know, for being realistic, I think we have to kind of calibrate our expectations. Like I said, it's not as easy to collect some of this data as it is to collect Scope 1 and 2 emissions data for a company or an investor. And I think, you know, it's a longer term challenge to make sure that Scope 3 emissions data is being collected and integrated into climate change action plans appropriately. So I think it's a longer term goal. I think there is some action underway to make sure that by many leaders in this field, to make sure that they're making progress as quickly as they can. But I do think our expectations, you know, can't be for, you know, an overnight switch to reduce Scope 3 emissions on behalf of companies around the world, because there's a lot of work that needs to be done to collect appropriate data to set realistic targets.
Thank you very much, Tyson. And that reminded me of when we speak about this issue affecting all sectors, one sector doesn't get as much attention usually, which is the agricultural sector, or especially the livestock or meat and dairy industry, which has huge, especially methane emissions as well. And I believe in Italy there is a case regarding that in the OECD multinational enterprise contact points. But I see in the chat, Conrado indicated that he wants to reply to a question that came up there. Would you like to, I see you want to reply to one or two. Would you like to select one?
Yeah, there are two questions. So the first question is from Carolina Garrido, asking the panelists on their thoughts on transnational private climate litigation, especially concerning cases being brought in global north jurisdiction against multinational corporations for climate damages or impacts being felt by victims in the global south. I think, and I think the Carolina's question is also closely associated with Vivian's question, so the next question about whether or not pursuing private climate litigation against corporations is effective. So I guess my answer to this question is, I think well, of course, ideally, in an ideal world, the goal of litigation is for the plaintiff to be successful on the merits of their claim, so to win the case. But in the case of climate change litigation, I think what's more important than that is that it's not about winning or losing, but the way that litigation can provide a media through which climate change awareness can be amplified, can be channeled to the larger public. And also, in addition to that, I think private litigation or any kind of climate change litigation is also a venue through which climate science is being developed and environmental law doctrines is also being developed. So, for example, in the case of Indonesia, the cases which I shared with you in my previous presentation, perhaps should those cases be tried by an Indonesian judge, say 10 or 20 years ago, that might not make any sense. No judge would gladly accept the plaintiff's inclusion of carbon emission in the compensation value 10 or 20 years ago. But today it's quite possible, because climate science has proven that there is a close association between wildfires and illegal logging to climate change. So I think regardless of winning or losing, I think climate change litigation, so litigating climate change is always a good call, because it challenges, it also introduces new developments on climate science and also climate law, or the larger environmental law. So that's for me.
Thank you very much, Conrado, for this statement. So we have 5 more minutes. I hope we answered most or all of the questions in the chat. What I would like to do now at the end is give each of the panelists a very short chance to give a last input that you thought, okay, I forgot to mention that was forgotten completely, just to briefly mention that. And if you can think of anything, say in a percentage from 0 to 100, the chances of likelihood of a private climate litigation being successful, whatever that means, in the next 2 years. Let's start with Michael.
Well, thank you. Well, answering your last question, I think we will see an increase of litigation on this regard, so not less, but more. And another thing I would like to point out, and building on Conrado's answer, is the role of the judiciary. Usually we're talking about lawyers here and bringing cases and how clever the avenues are, but I would like to make a sensible comment about the judiciary. We, as judges, there are a community of judges being gathered under the IUCN project for this World Judicial Institute, where they have been for a couple of years exchanging ideas. Well, we sat with the judges from Uganda, the Supreme Court of the UK, etc. So there's a cross-pollination. So I would say that, as Conrado mentioned, of course, 20 years ago, it might be nuts to think about this kind of actions, but nowadays is the effort of the communities, the advancement of science, but as well this effort that judiciaries are opening towards new arguments and new ways of dealing with this kind of problems. Environmental law is a bit difficult. Again, it has its own principles, etc. Its own evolution. So I would say this is more complex than just to bring forward litigation. It's one part of essential, but it's not the unique. Thank you.
Thank you very much, Bernard. The floor is yours. A very brief final statement from your side.
Yeah. Thank you so much for giving me the opportunity. I want to highlight one barrier that is prevalent in African jurisdictions, and this is the point of lack of access to information. For some of these climate litigation cases to succeed, you need access to information, and accessing information in this part of the world sometimes is difficult. And although the laws are there that provide for access to information, it is in practical terms, it is very difficult to access this information. It is not strange to request for information, and the concerned agency or private corporation just ignores you, and you find that without that information, the case cannot proceed. So this is a very serious barrier as far as Africa is concerned, and it requires some little bit of more research. Thank you.
Thank you very much. Carolina, please, very briefly as well. We're almost running out of time.
Yeah, thank you very much for this opportunity again. So I think the trend is rising. So we will see, even in Italy, a litigation trend in the near future, especially because if we have more regulation, we will have more litigation. And if we are in the context of the European Union, which is about to enact new directives, which will affect all the European countries on, for example, the proposal on this human rights and environmental disclosure, or the directive on directors' liability, then we will have consequently more litigation. And also in Italy, we have this new class action regime, which will definitely increase the litigation from the victims of this kind of behavior, not environmentally friendly behavior. Because this class action could be brought also by non-consumer, so everyone can actually bring this type of claim, and with everyone, I mean also small corporation or investors, which are that usually more loaded than the single private litigants.
Thank you very much, Carolina. I'm very sorry, Conrado and Thijs. I believe we're running out of time, but I hope you had enough opportunity to speak. But we have a keynote coming up, and I don't want to ruin the time, the schedule. So I'll thank everyone of the panelists and all the participants in the chat. I hope you learned a bunch. So did I. And with that, I'll hand back to Maria Antonia.
Thank you so much, Andreas, and thank you to all the panelists. It was an excellent discussion, and very engaging questions as well from the audience. So we really appreciate it. So now we're going to be moving to our last panel of the day. We will continue tomorrow, but we have with us as the keynote speaker to close us for the day, Professor Dr. Ian Fry, who is a senior lecturer at the Australian National University and the newly appointed Special Rapporteur on the promotion and protection of human rights in the context of climate change. So we're very fortunate to have Professor Fry here with us after his very recent appointment. So just without further ado, move over to you.
Well, thank you very much. It's a pleasure to be here. And I have to say, you know, based on your introduction, that I have to say these are very preliminary views. In fact, my appointment hasn't officially started yet. So you've jumped in early to get me into this session. So I was asked to sort of talk about my perspective on climate change litigation in island countries. And again, you know, my background is primarily around climate change negotiations under the Paris Agreement and representing Tuvalu at various negotiations, particularly around the Paris Agreement. I was actively involved in providing an overview on negotiations for the least developed countries, because Tuvalu is a least developed country. But just to run you through some cases that have sort of surfaced particularly in islands and more particularly in Pacific Island countries. The first one I wanted to look at was in 2011, and it was brought by the Federated States of Micronesia, which actually invoked considerations of environmental impact assessment by the Czech Ministry of the Environment. So here we have a small island state, you know, questioning decisions made by the Environment Ministry over the proposal of construction of a brown coal-fired power plant. And it did, in effect, the Czech Ministry did find that the Micronesia was an affected state, and that the ministry required this company group to develop a compensation plan which would offset 5 million tons of CO2. So this is quite an interesting sort of example of, you know, transboundary impacts on a broad, you know, global scale. So that sets some sort of interesting precedents around that case. One particular closer to home was Juliana Case versus the Ministry of Business in New Zealand. Juliana Case was an Kiribati citizen who moved to New Zealand and sought a claim of climate change refugee status. And based on the fact that where he lived, there was damages caused by storm surges. He went through various sort of court cases in this, and it eventually ended up in the Supreme Court of New Zealand. And each time his claim was rejected. And based on the grounds that the term climate change refugee does not have status within the UN Convention on Refugees. And this is an interesting point, and I'll return back to that one again later at the end. But the Supreme Court did note that the decision does not rule out the possibility that environmental degradation resulting from climate change or other natural disasters could create a pathway into the Refugee Convention or protected person jurisdiction. And that's something I want to look at again. There have been a couple of cases in the Torres Strait. So these are small islands that connect Australia to Papua New Guinea. And there was a case of what's called the Torres Strait 8. 8 people from the Torres Strait sought a formal complaint against the Australian government with the Human Rights Committee concerning their impacts, particularly looking at the first optional protocol to the International Covenant on Civil and Political Rights, and that these individuals claimed their rights under this covenant had been violated. The Australian government sought leave with the committee to dismiss this petition in 2020, and so this is an ongoing situation. Another case brought by Torres Strait Islands is the Pabai and Guy Paul Kabai versus Commonwealth and Australia. And this is a case brought to the Federal Court of Australia alleging that the Commonwealth owes a duty of care to Torres Strait Islanders to take reasonable steps to protect Torres Strait Islanders, preserve island custom, and to protect the marine environment from the impacts of climate change. This case is still ongoing, and this will be considered, as an ongoing case. There's an interesting little case that occurred in Papua New Guinea around, which was called Morua versus China Harbour Engineering, which was a proposal for a small bridge to be built across a river, and the traditional owners of the land made claims against this construction, and cited climate change as one of the elements within this. And the Supreme Court found that that there was reasonable grounds for consideration of climate change and human rights issues associated with it. Should be able, and the court found that people should be able to complain of a breach of human right and have their complaint judicially decided without undue difficulty. So this is quite an interesting case because it both invoked a human rights element and a climate change element as well. So that's interesting, just small case that sort of brings out some of these issues. Of course, outside the Pacific, we've seen case brought between by the rights of children. Haitian children petitioned the Inter-American Commission on Human Rights to redress human rights violations stemming from waste disposal in their residential district. But they also invoked concerns about climate change. And that's an interesting case on that area. One of a sort of a broader nature, which is being considered at the moment, is a proposal by the Vanuatu government to seek an advisory opinion in the International Court of Justice on the rights of present and future generations to be protected from climate change. This is an interesting case. I have sort of mixed views about the efficacy of taking this case, but and maybe we can discuss that later. But so this was brought before Pacific Island leaders at the Pacific Island Forum in 2019 and has been pursued by various non-government organisations and the government of Vanuatu as well. Because it's an ICJ case, it would require a reference from the UN General Assembly, a resolution, and therefore Vanuatu has to sort of build a case for the development of a UN General Assembly resolution to bring that forward. There isn't a lot of litigation from island countries, particularly in the Pacific, around this issue, but there are these sort of interesting examples where we're looking at sort of climate change refugees. We're looking at cases invoking climate change and connections to human rights. Some correspondence suggests that this connection between human rights and climate change is an interesting area, and it is certainly growing. Some argue that it's a sort of a filler to plug the accountability gap left by climate law. And certainly, this is something I'll be looking into as the special rapporteur Is it just a filler, or is it, you know, a legitimate issue that should be brought forward? Certainly, some of the issues, and, you know, I think some of the discussions discussed earlier, is that it's, you know, this sort of connection between human rights and climate change. You know, there are obviously areas of impacts, and particularly around, you know, the impacts of severe weather events on people. And but I'll also be looking at the sort of issues around the impacts of actions to take action on climate change, as far as, you know, their human rights implications as well. For instance, mining of minerals to make batteries, hydroelectric dams, and things like that, all have human rights impacts, you know, through mitigation actions under the climate change arena. So they're just some of the areas that, you know, I'll be looking at. And I want to return to this sort of climate refugee case, because I think it's an interesting area. And I feel that there is a gap in international law with respect to people displaced as a consequence of climate change. And recent studies by the IPCC, the Working Group 2 report, and other reports suggest that on average, 1,000 people per day are displaced as a consequence of climate-related events. That's either, you know, internally displaced or displaced across international borders. And these people, if they're displaced across international borders, as we saw with the Te Teota case, are not defined as refugees under the Refugee Convention, although some people argue that the concept of persecution could be used in the context of climate change, though I'm, you know, remain to be convinced by that argument. So, you know, the issue is, do we need a new form of law to give protection to people displaced by the impacts of climate change and across borders? And this is clearly going to be a growing issue and a significant sort of global issue worldwide. We're seeing these sort of cases and issues appear in a lot of areas, in South Asia and sub-Saharan Africa, and of course in the Pacific, where you know, people are facing internal displacement and external displacement. And just to give you an example, in 2015, Cyclone Pam hit 3 of the islands in Tuvalu and sent waves across the entire island. That damaged infrastructure, it destroyed crops, it contaminated the water supply. So a number of families, over 40 families, had to move from that island because it was no longer inhabitable and moved to the capital. So this is a situation of a global impact of forcing people to migrate internally. And so, you know, are there, you know, necessary requirements to give protection to people for internal displacement as well as external displacement? I was listening intently. It came online about some of the discussions in the previous session, and I certainly the issue of corporate social responsibility with respect to human rights and climate change is a growing area, and certainly this will be something I'll be looking at. You know, particularly looking at how the work of the European Union is advancing in some of those areas, and you know, is this an area that can be advanced in other places? And I guess, you know, overall, I'm at the moment still very much a sort of a sponge in these areas, trying to absorb as much information as possible, and you know, trying to explore where there are legal gaps in international law with respect to human rights and climate change. So that's where, you know, I'm sort of thinking at the moment, and you know, glad to be brought into this discussion, and quite happy to take questions and commentary. So thank you very much for inviting me.
Thank you very much, Professor Fry. It's really an honor, because we're really listening to some of the some of the crumbs of what you will cover throughout your mandate. So it's really a privilege to be listening to that. I wanted to just tell everyone that feel free to type questions in the Q&A, but I do have some of the questions based on what you were saying, some of my own research as well on climate litigation. You mentioned that your experience is mostly on the negotiation side. So considering some of the frustrations on the negotiations on loss and damage, do you think that's an area that we still haven't seen a lot of litigation in yet? So do you think that's going to increase, and how do you think that could be done?
Yes, thank you. I get a bit of a twitch when you mention loss and damage, because I was sort of actively involved in the second last night of Paris Agreement, sitting down opposite lawyers from the United States, trying to hammer out Article 8 on loss and damage. So and of course the what is it, paragraph 52 of the decision, which refers to limits, liability and compensation. Which was the deal struck basically between Senator Kerry and the Prime Minister of Tuvalu at some late hour of the night on the second last night to have that sort of exclusion clause. I think certainly loss and damage it will be a growing area of litigation because we're seeing people suffering as a consequence of climate change, and there is not a lot of action at the moment. And so I seriously think there will be. Of course, there are other issues of, how do we provide recompense to people who have been affected by the impacts of climate change? There was some discussions in the Glasgow COP about establishing a new funding mechanism to deal with loss and damage, and that's still an ongoing discussion. I think it was sort of the ideas of how that fund would operate are still being considered, but that's certainly one area where, we not only are there going to be growing litigation, but there has to be some funding arrangements to assist countries to deal with that. In just to say that we one sort of microcosm of that is, in the Pacific, we looked at a Pacific climate change insurance facility as a way of, it was an index-based insurance facility based on some climate change thresholds, sea level rise, storm surge height, and things like that. That's still an ongoing area, but of course that's just an index-based insurance mechanism. It doesn't pay for the full costs of damage that are incurred by island countries.
Thank you. One other area that I think you mentioned briefly, but that I've been very interested in looking at it a lot is this issue of extraterritorial responsibility and the transboundary impact, which I think maybe could address a little bit of the loss and damage aspect as well. I've studied a lot the advisory opinion of the Inter-American Court on Human Rights, sort of started to establish some of the parameters of extraterritorial responsibility, and that rationale was then picked up by the Committee of the Rights of the Child on the Saatchi case as well. So do you think that maybe could grow and extend to sort of other jurisdictions and regional and international adjudicatory bodies as well?
Well, it's inevitable that this will certainly grow, is a growing area of law, I guess, extraterritorial responsibility. It's incremental at the moment, and obviously there is a lot of pushback around that, but it's certainly an area which will inevitably develop, and perhaps needs to be pushed along by considering what sort of legal measures are required to do that. And I guess it'll be interesting to see how these requirements that are being developed in the European Union may help advance that area as an area of law to be developed, I guess, to rather than just sort of testing the waters, to actually develop legislation at the international level, international law, to make this clear that there is extraterritorial responsibility.
Thank you. There are a few questions here in the chat. So one's from Juliana Case. So she's asking, you know, on this issue of the refugees that you already touched upon, whether you think there will soon be a refugee crisis caused by climate change, and whether climate change can be a threat to peace and security.
Well, it's certainly, you know, an issue that's been looked at. You know, a lot of defense departments are seeing this. You know, they're talking about climate change being a threat multiplier, and we're seeing, you know, tensions rise as a consequence of people displaced across international borders as a consequence of climate change. So this is certainly a significant area of concern, and no doubt will be a sort of growing area of law, I guess, and you know, I think there is an urgent need to address this sort of what I consider as a sort of legal gap in the protection of people displaced as a consequence of climate change, and we need to do something fairly soon about that.
Wonderful, thank you. There's another question from Linnea Nordlander, whether you think there are ways alongside or other than litigation that human rights can supplement the loss and damage gap in international climate change law.
Well, yes. I mean, obviously, litigation is just one avenue of dealing with this, and certainly we have to, you know, develop the full toolkit around this. I guess there's certainly, you know, funding mechanisms are certainly necessary. You know, sort of guidelines for corporate responsibility are other areas. There's, I guess, a whole suite of measures, and I certainly haven't sort of considered all of these yet. You know, obviously this will come as I sort of work into my position to look at the sort of other measures that will be required, and litigation is just one sort of tool in the toolbox, I guess.
Thank you. I have another question, maybe that directs more to your future role and mandate, but we do track at the Sabin Center's database some of the direct complaints related to climate change that were made to other special rapporteurs, the Special Rapporteur on Human Rights and the Environment, and some others. We have two currently in our database. So I was wondering what you think about sort of that, you know, that avenue for complaint by you know, plaintiffs and or NGOs as part of your mandate.
Well, I haven't had a chance to sort of go through all the examples from the other special rapporteurs. So again, you know, this is a steep learning curve for me in this area, and so I haven't had a chance to look at those. But obviously, you know, I'll be looking into that and seeing where there are opportunities. I think, you know, that there are interesting sort of situations where people are trying all avenues, as we're seeing with the Torres Strait Islanders, to try and get some sort of recognition of their concern. And this is critical, I guess, that certainly, you know, legal NGOs are exploring all avenues to sort of draw attention to the plight of people around the world. And the case of the Torres Strait Islands is just one of those. And I think we'll see a lot more, you know, developing around that area as you know, people explore various legal options to draw attention to the plight of people affected by climate change.
Thank you. So I think we do have questions for, well, time for maybe one or two more questions. So maybe we'll switch to the ICJ advisory opinion. You did mention that briefly, that you had some doubts about the campaign and about the role that the ICJ could take. I know that there have been some criticism whether the ICJ is ready or not to listen to climate change, but maybe you can talk a little bit more about that.
Yes, thank you. I guess, I mean, traditionally ICJ is considered disputes between countries, you know, territorial disputes and things like that. And the question is, you know, is this a question appropriate for the ICJ to consider? And, you know, is the answer there already? You know, and the ICJ can only consider what's, you know, present in law, I guess, and certainly they could look at the preamble to the Paris Agreement, which talks about sort of intergenerational equity. You know, look at, you know, human rights resolutions on safe environment to give them some guidance on that area. But perhaps they would argue that there isn't sufficient evidence to show that there is a requirement to protect future generations. And that could be a significant backward step if they found in that direction. So there are I guess, you know, limitations to what the ICJ can do in this case. So of course, you know, it certainly brings the issue to the fore, and certainly, you know, it certainly highlights this issue as a global issue. But whether the ICJ is the right forum to sort of discuss this issue, I'm not sure. But there may be others. Certainly, there are a lot of lawyers and supporting this case, and so you know, I stand corrected on this, and you know, hope that it is successful.
Do you feel the same way about the campaign for ITLOS, for an advisory opinion from?
Well, yes, that's another interesting one. You know, the government of Tuvalu and Antigua and Barbuda sort of formed this this grouping at the last Glasgow COP to sort of look at ITLOS decisions. I think, you know, that would be a more useful process, because it does sort of bring on board the law of the sea and its implications for protecting the environment under that. And I think there are, it seems to be closer to its mandate to look at the sort of issues around climate change. So I suspect that would be an interesting one to look at. Certainly in the Pacific, we know that, you know, the warming ocean is affecting fish stocks and you know, and causing fish stocks to migrate. And so there are significant implications for human security in that context. We know that ocean acidification is affecting of fish stocks again. Young tuna are affected as a consequence of ocean acidification. So there are, you know, already sort of observed impacts in the sea that could well be brought forward under ITLOS.
Wonderful. Thank you so much. This is actually really helpful to think through. And so I have one last question. Since you mentioned some of the impacts on the biodiversity and do you think that would also be sort of part of your overview of the impacts on climate change and in addition to human rights?
Sorry, did you want to say that again? I missed that. Apologies.
That's okay. I was wondering about the impacts on biodiversity as well. So if you plan on covering that too as part of your mandate. Yes,
well, I mean, this is a discussion I'm going to have with a special rapporteur on the environment, the protection of the environment. Clearly, there are very close interlinkages between the impacts on biodiversity and human rights. I recently attended a discussion between indigenous peoples of Brazil with a meeting with the European Parliament and explaining their circumstances at the moment in Brazil. And obviously they were talking about the impacts of deforestation on their own livelihoods, on biodiversity, on environment in general. So there are very close interlinkages there between, you know, human rights issues and the protection of biodiversity are closely interlinked. And it's no more the case in the Pacific, where Pacific Island people are, you know, closely connected through their lifestyles to the protection of biodiversity.
Wonderful, thank you. I always, I'm from Brazil, so I always appreciate when shining a light on what's happening there. There's a lot of litigation going on too at the Supreme Court, so it's definitely an interesting perspective. So there's one final question, and then we can close the panel. So there was a question on whether there are any specific types of complaints that you would welcome in order to have the opportunity to clarify the applicability of human rights. So Marley said, in particular, I think about claims about approval of specific new fossil fuel related greenhouse gas emitting activities.
Yes, that's a good question, and certainly, you know, I'll be exploring these sorts of complaints. You know, I have to, I guess, tread carefully about, you know, specific cases at this early stage. But, you know, undoubtedly, as we've seen with other special rapporteurs, you know, that they have been asked to intervene in certain cases around particular issues associated with human rights. So, you know, I'll certainly be looking at some of these complaints and you know, considering how best to intervene in those areas.
Well, thank you very much. We know we have lots of questions about what you plan on doing. So I think we're all very anxious to see what you will do with the mandates. So I certainly appreciate you coming in and talking to us even before your mandate has started. I know also it's very early for you, so I appreciate you waking up at this early hour to join us. And I hope we have many other opportunities to talk. We'll definitely be inviting you again to talk to us at the Sabin Center. You know, we're available if you need any support as well. So we really look forward to engaging with you and wish you the very best of luck as your mandate starts.
And thank you very much for inviting me. And I again apologize if, you know, my thoughts are very preliminary at the moment. It's a steep learning curve for me, and hopefully I'll be better informed when we speak again.
Not at all. It was very, very informative. And I actually will follow up on the Papua New Guinea case because I think we don't have that in our database. So I'll definitely want to add that in there. Thank you very much. And to all of our attendees, we'll begin tomorrow again at 9 a.m. Eastern Standard Time. So we'll hope you join us tomorrow too. We have a wonderful set of panels and of keynote speakers as well. So we thank you for joining today, and we'll see you tomorrow.